already, Your Lordship, they had appeared, Your Lordship, before the police to record their statements. But it was on the pretext that the Kamaikha ongoing duty is going on, and thereafter, Your Lordship, they have arrested it intentionally. So, Your Lordship, I may allow Your Lordship, kindly matter may take on urgent basis on Act 2, Your Lordship. Already one pre-arrest bail,
It's a division bench matter.
single bench, Your Lordship. Single bench, Your Lordship.
No, we are sitting division in division now. So you're mentioning before the single bench.
When the single sets, you can mention.
Division bench item 1 for motion W54526.
Malak, this matter is actually for single bench. It should be listed before the single bench. Transfer matter.
This is against the judgment and order of this Central Administrative Tribunal, right?
No, Mr. I have challenged the transfer order.
Transfer.
Transfer order,
order.
yeah.
Service
It's a
matter.
transfer order, service.
Single.
It will go to single benches.
Maybe on 2 minutes.
Okay, allow it. Let the matter be listed before the single bench.
All right.
Hmm? When do you want it? When do you want it?
2nd July.
2nd July, yes, second,
Okay.
2nd July. Let it be.
Item 2.
Yeah, this is again,
Yes.
this is against
So
this.
item number 2 and 4 are analogous matters.
Correct.
I request my lord to take up 4 first, my lord. I prepared from item number 4.
Yes.
There are 4 to review. Make please, my lord. So both these
One
matters.
second, let the brief come.
I'm so sorry, my lord.
Yes.
So both these matters pertains to a challenge to the judgment and order passed by the CAT, whereby the original application filed by the applicant was dismissed on the first day, my lord, on the ground that the CAT did not have the jurisdiction to entertain the original application. Now,
Yes.
before I take my lords to the impugn order,
Hmm.
may I kindly take my lords to the facts of the case? I'll be very quick, my lord. What
Yes.
is the facts, my lord? My lord, in terms of a guideline, which my lord would find at page 28
Hmm.
of the writ petition,
Hmm.
the government of India had formulated a scheme, my lords. Page 28, if my lord has it.
Yes.
So, my lords, the scheme was for establishment of model rural health research units in the states during the 12th plan, my lord, in the year 2030. In terms of this scheme, my lords, if my lord comes to page,
The scheme is for how many years? 5 years.
there's no outer limit to the scheme, my lord.
Okay.
The scheme is for establishment of model rural health research units in states, different states in the country, my lord.
Hmm.
If my lord comes to page 32 for a moment, my lord would see at clause 4, the scheme is of the Ministry of Health and Family Welfare, but the implementing agency, the agency is vested on ICMR for clause 6, my lords, 6.1. The
Yes.
scheme will be
Council of
executed
Medical
by the
Research.
Indian Council of Medical Research,
This is the executing authority.
executing the implementing or the executing
Correct,
authority.
correct.
Arrayed as respondent number 2 and 3 in the instant writ
No,
petition.
right, right.
If my lord comes to
Hmm.
page, I'm so sorry, my lord, page 48 for a moment, my lord, which is an appendix of the scheme, my lord. My lord would see that the health units envisage the core staff, my lord. My lord would see, if my lord, I'll read it out. Core staff to be provided at each MRHRU to be engaged on contractual basis on consolidated remuneration till creation of a regular post. My lord may kindly mark it, my lord. It says till creation of a regular post. And if my lord comes to clause 3, this is the post I'm concerned with, my lord. Technical assistant statistician. Now, pursuant to the scheme, my lord, in the year 2013, if my lord turns the page, an advertisement was issued, my lords, to fill up those posts, my lords.
Page?
Next page, my lords, page 49. we are concerned with MRHRU Sabua, my lords. A health research unit was established in Sabua and an advertisement was floated on 7/10/2014. I applied for the post at point number 3,
Technical assistant.
technical assistant, statistician, 2 posts so and so.
Mm.
Now, my lords, may kindly come to page 52 for a moment, my lords. After
52.
successfully clearing the advertisement, my lord,
The appointment was given to you.
appointment was issued, my lord would mark the date 9/6/2015
Mm.
and the offer of appointment clause number 1, which is very important, my lord. It says, my lords, the post is temporary on contractual basis and is co-terminable with the scheme. It is co-terminable with the scheme, meaning thereby the post will be liable to be terminated if the scheme is terminated, my lord.
Okay.
So unless the scheme continues, they'll continue, my lord. Since 2015, my lord, I have been working as a contractual employee without any blemish, my lord. Now, what had happened in the meantime, if my lord comes to page 56 for a moment, my lord. The names of the post, my lord, the nomenclature rather, was changed, my lord, in the year 2024. Page 56, my lord, has it. It's dated 18/10/2024. Subject amendment of guidelines of ICMR non-institutional project human resource so and so. If my lord turns the page,
So ICMR has basically come out with a policy that they will be outsourcing it, right?
yes, yes.
So
yes,
that's
yes,
why they have issued this expression of interest.
Yes, yes.
Correct.
Thereafter, my lord, the nomenclature was changed. My lord comes to
No. Now
Yes.
tell me one thing. Now ICMR has come up with this policy decision.
You're right.
Now can you stop this?
No, my lord, that policy decision,
Mm.
my lord, the answer,
Mm.
I would like to reply in 2 points, my lord. The first point,
Mm.
the ICMR did not have the jurisdiction
Mm.
to issue such guidelines, my lord.
Mm.
And even assuming ICMR had the jurisdiction,
Mm.
that would be against the law laid down by the Supreme Court, starting from Pyara
No,
Singh. which is
ICMR is the executing agency, right?
implementing.
Implementing
Now, what
agency.
the ICMR did, my lord,
Mm.
if my lord comes to the last page for a moment,
Mm.
I'll show my lord.
Mm.
An RTI was filed, my lord, page 61. I'm so sorry, my lord. Page 61. My lord has it.
Page 61.
61. An RTI was preferred by the present petitioner,
Mm.
Pranab Gogoi, my lord.
Mm.
Question number 1.
Mm.
Kindly provide a certified copy of any circular, office memorandum, order, communication available with DHR regarding the maximum tenure so and so, maximum service limit of contractual staff engaged under DHR so and so. It is informed that no such circular. Well, the RTI replies by the Ministry of Health and Family Welfare, Department of Health Research, who had floated the scheme. The scheme is of the Government of India, my lords. The Government of India says, my lords, it is informed that no such circular, office memorandum, order is available with DHR regarding the maximum tenure, maximum engagement period, maximum service limit of contractual staff under DHR so and so, so and so. Next, my lords, DHR has not received any circular, office memorandum, order, communication, ICMR headquarters, New Delhi, regarding the maximum permissible tenure for the project staff engaged in ICMR so and so. Next, my lords, DHR has not issued any orders, instructions, communications to any mentor institute of MRHRU regarding the implementation of so and so, so and so. Now, my lords, without the concurrence of the Government of India, can the implementing agency change the terms and conditions, my lords? That is the first point. They could not have done it. Secondly, my lord,
Is there any scope of purpose or scope of work while engaging ICMR?
yes.
Where is that?
That the initial appointment letter, my lord. is
No,
referring-
initial, I mean, that ICMR will act as an executing or
Yes,
implementing
that is there.
agency.
That is there in the scheme itself.
Where is that scope?
Page 28, my lord.
Phase?
28, it starts from 28, the scheme,
Of the
and the
implementation.
relevant portion, my lord, would find at page 32. Agency for implementation of the scheme. That is funded by the Government of India. Everything is done by the Government of India.
Okay, this much only?
This much, and my lords, the law my lord, what this honorable CAT did, my lord, just a few submissions on why the impugn order passed by the CAT.
So your basic argument is that whether this ICMR has the power or not.
ICMR has
I-
the power or not. Secondly,
see,
my lord, it
uh,
would be against the law laid down in Pyara Singh, my lord. I have quoted Pyara Singh. It is no longer res integra, my lord, that a contractual employee
Cannot be
cannot be replaced by another set of contractual employee. And the second ground, outsourcing, my lord, the Supreme
No,
Court,
no, here the thing, the facts is little bit different.
little bit
See,
different.
facts is different means,
Yes.
see, the ICMR has come up with initially they have engaged some contractual employees, right?
Yes, contractual.
Now they want to go ahead with, I mean, they may be having some logistical issues or whatever, I don't know, regarding contractual employees. So they thought that we'll go for outsourcing it.
Yes.
So that's why they have gone for outsourcing and they have called for an expression of interest.
Right,
And accordingly, one agency was engaged.
right.
Who has bid, I mean, like that because they are successful, he has been engaged.
Indeed.
And now this person,
Yes.
the person before us, he has I mean he has been taken over
Yes.
by
Exactly.
that
New person.
outsourcing also
Yes.
agency, right?
Yes.
Now the outsourcing agency will have their own kind of
No, my lords, that
I'll
address my lords on that.
before joining outsourcing agency, did you raise any objection?
No. I did not raise any objection. I'll come to that, my lord. That's a very pertinent question, my lords. If my lord comes to the second appointment, which is with the outsourced agency, page
outsourced
57 for a moment. Page 57.
57 years.
Now, the Supreme Court has already dealt with such kind of situations. Well, I'll read it out
No, that
first.
will come later.
Yes, yes.
Let us be first clear about the
Yes,
facts.
clear about the facts.
So this is on the basis of your application.
Not on the basis of my application. My lord, I'll kindly read it, my lord.
Hmm.
With reference to your application
Hmm.
and subsequent interview you had with her client.
Hmm.
Client meaning ICMR. I did not sit for interview before the private company.
Hmm.
We so-and-so have the pleasure to offering you a job of field investigator.
Hmm.
Field investigator, why, my lords? Because ICMR had changed the names of the designation.
That nomenclature has been
Yes,
changed.
nomenclature has been changed.
Hmm.
Your appointment is, however, subject to the following. Number one, you are required to report to work above mentioned date on or before, failing which the offer will stand automatically withdrawn as per contractual terms of ICMR. Now, I'm governed by the contractual terms of ICMR. The test ought to have been, my lords, that who is the, my lords, the actual and the real person, my lords, who's the employer. And that test has been identified by the Honorable Supreme Court in a number of cases. Well, I'll place those cases if required. In fact, a recent Sikkim High Court judgment, my lords, dicto facts, my lords, the same ground was raised that since she was an employee of an outsourced agency, a private agency, a writ was not maintainable. Now the High Court had answered, no, it's not correct because you have to see what job and duty is functioning. For the last 11 years, I'm working in the same station at Sabua, my lords. 11 years of service. All of a sudden, and what is the reason? They want to, it's not that they want to engage a regular set of employees. I would not have any objection, man. I'm 43 years old now, serving for 11 years. Now I'll place that judgment, my lord. Judgment of the Honorable.
No. After this, what happened?
After this, my lords, see, my lords, and the Honorable CAT.
ICMR has come up with a policy, right?
No, not a policy. My lord, the impugn order, which was impugned. My
There
lord,
was some guideline or something
Yes,
they have come up with.
Yes, that is at page number, the first impugn order, page
No.
number 60.
What was the reason that you have been asked to leave?
My lord, the reason is, if my lord comes to page 60, the second impugn order, I'll read it out, my lord. My lord, I'll start from the second paragraph. The first paragraph, this is in reference to a communication pertaining to the maximum tenure project. The existing guidelines which clearly stipulate that no circumstances shall any project staff be permitted to continue beyond 5 years. So there was a request that you disengage all contractual staffs who have crossed more than 5 years. When it was issued to the director wrote to ICMR saying, you give us some time, we cannot do it so early. And this is the, my lord's letter. However, considering the justification provided by your office And in order to ensure a smooth transition from existing personnel to newly appointed staff, the competent authority has decided that a one-time extension may be granted. Accordingly, all project staff, including those under MHR, MRHRU, VRDL, etc., who have already completed more than 5 years of service, may be allowed to continue for a further period of 3 months only, which expires today, my lords. During this extension period, the institute is required to complete the process of replacing, my lord, on market all such staff with new project personnel through appropriate outsourcing agencies, strictly in accordance with the prescribed guidelines. No further extension beyond this period shall be considered. Now, I was challenging a public document, my lord, issued by an instrumentality of state under Article 12. That was not considered by the CAT. I was not challenging a private order of the outsource agency. Outsource agency is just an intermediary, my lord. Payroll intermediary, it's called. The payment is made to the outsource agency and the agency pays me. That's the only role of the outsourcing agency. May I kindly place the Sikkim High Court judgment?
After
Yes.
this extension, the new advertisement was issued.
Advertisement has not been issued, madam. So I'm basically praying for protection that status quo may be granted, madam. This aspect has to be considered.
So was the Sikkim High Court.
Sikkim High Court, madam. I'll just place it, madam.
Advertisement again.
Here the writ petitioner was an outsourced office assistant. First paragraph, my lord. Ms. Reena Kumari, an outsourced office assistant, Hindi, engaged by Regional Ayurveda Research Institute, respondent number 2, has preferred this instant petition. The first respondent is the secretary, so-and-so, Government of India, Messrs. Third Eye Security Guarding Private Limited, which in the instant case is e-solutions, my lords, having it so-and-so, who is the contracted with respondent number 2 to deploy manpower to them in the respondent number 3. The petitioner challenges office order dated so-and-so, impugn office orders terminating the engagement of the petitioner issued by the respondent number 2 and communication dated so-and-so issued by the respondent number 3, informing the petitioner that her association with respondent number 3 is temporarily discontinued due to the expiry of the contractual terms between 2 and 3. By this impugned communication, the petitioner was also informed that her future association with respondent number 3 is subject to finalization of a new valid agreement. The petitioner seeks alternative prayer for modification of the two communications. Now, my lord, to directly come what the court held, my lord.
Para.
My lord, start from paragraph 13. I'll very quickly read it, my lord. Yes, paragraph 13. My lord, have it? 13.
Yes.
Internal page 14. From the pleadings as well as the documents on record, it is evident that the contract of outsourcing the staff between the respondent number 2 and 3 was to be pursuant to the guidelines issued by the respondent number 1. It is also clear that the respondent number 3 did not issue any appointment letter specifying terms and conditions of the contract to the petitioner. The record reveals that even the renewal of the petitioner's contract was communicated between 2 and 3 only, without any information to the petitioner. The record reveals that the petitioner was put in the respondent number 3's list of outsourced employees on the direction of the respondent. The record further reveals that petitioner was engaged for a further period of so-and-so by the respondent number 3 on the direction of the respondent number 2. It also suggests that respondent number 1 and 2 did enjoy the power of termination of outsourced employees under the guidelines, even though they were issued appointment letters by the respondent number 3, which is the outsource agency. Evidently, the recommendation to employ the petitioner, her salary structure, renewal of her engagement from time to time, her leave as well as termination was at the instance of the respondent number 2. Here, respondent number 2, ICMR, and under such direct control, save the payment of the salary through the respondent number 3 from the funds of so-and-so. The respondent number 2 enjoyed total control on the engagement of the petitioner. 14, an outsourced employee is normally an individual who is employed by a third party and assigned to work on behalf of another organization. The relationship between the outsourced employee and the company that engages them can, however, vary depending on the the terms of the contract. Generally, the outsourced employee is an employee of the third party who is responsible for their salary, so and so, so and so. This is, however, dependent on the terms of contract. The terms of contract between respondent number 2 and 3 allowed the respondent number 2 to have direct control over the outsourced employees regarding inter alia, her appointment, her work, her salary, leave, termination. Ideally, the respondent number 3 ought to have entered into a written contract with the petitioner as per the guidelines. The respondent number
Yes, understood. I mean, your thing is that since your terms and conditions or
I'm
whatever appointment, though appointment letter has been issued by this e-solutions or
there's
whatever,
no terms and conditions.
solutions or whatever, but basically it has been guided by
Same.
or as per the directions of the ICMR. So you were saying that like in your appointment that there is a full control or managerial control or whatever
Supervision, control
from the
that is-
ICMR, and since ICMR is a state, it is maintainable.
Exactly.
But I mean that it is maintainable, so like CAT shouldn't have this
And the
dismissed
other
their
thing
case.
is-
Only saying that like they don't have jurisdiction because you are outsourcing person.
My lord is aware of section 14. 14 of the Administrative Tribunal Act.
Okay, I think this matter will require some consideration.
Yes.
What, anybody is appearing for that? I
The
mean,
government of India does not have any notice has to go to ICMR. madam.
I'm appearing for Union of India.
ICMR notice has to go, madam. Itself provides, my lord, I should not be replaced until and unless a regular appointment is made. The scheme says it, my lord, I don't say it. You have to follow the scheme. Appointment letter says that it is co-terminus with the scheme. Scheme is still going on. I've gained experience for 11 years. Now they want to terminate, my lord.
you've been working for
11 years.
11 years.
Since 2015.
Okay, right done. I mean, heard Mr. P. Mohanta, the learned counsel, appearing for the appellants. Appearing for the petition, appearing for the petitioner. Also heard Mr.
As Chakraborty.
S. Chakraborty for Union of
Respondent one,
India,
Union of
for respondent number 1, Union of India. This is a writ petition challenging assailing the order dated 25/6/2026 passed by the Central Administrative Tribunal Gauhati Bench in OA number 040/206/2026, dismissing the original application of the petitioner on the ground of lack of jurisdiction. Full stop. Next panel. Mr. P. Mahanta, the learned counsel appearing for the petitioner, submits that the petitioner has been engaged
Nine 2015, my lord, initial appointment.
has been engaged as technical assistant in bracket statistician for the Department of Health Research Scheme. That's in quotation, establishment of a model rural health research unit in the state of Assam. And accordingly, he joined in Sabua as technical assistant, in bracket statistician, which is which is of a temporary nature. No, his appointment is of in the next line, right? His appointment is of a temporary nature, temporary nature with the option of renewable on 6 monthly basis, subject to satisfactory performance. Full stop. He submits that after his appointment, he has been working in the aforesaid center of Sabua for last 11 years. Last 11 years. He submits that, however, where is that? This thing 56, no, page 56. That's
Here.
56, no, not 56.
Advertisement to it, sir. 49.
Hmm. This was issued in 24.
Who-
That expression of interest,
Yes, yes.
24. Okay, however, in the year 2000, in the month of October 2024, the ICMR has issued an expression of interest in bracket EOI to empanel agencies to provide manpower on outsourcing basis at Indian Council of Medical Research Headquarters, New Delhi.
R4 was the successful bidder, my lord, and was in panel.
In terms of the aforesaid expression of interest, the respondent number 4, that is
E-Solutions.
E-Solutions IT Services Private Limited, got selected, and they have been appointed as the outsourcing agent for providing manpower in those centers of ICMR, full stop. After the selection of the outsourcing agency, the
Yes.
outsourcing agency, that is respondent number 4, has issued a letter dated 11 November 2024 to the petitioner offering him the job of field investigator in bracket project technical support -3 bracket complete, and his joining that has been mentioned as 11 November 2024. In terms of the aforesaid letter dated 11 November 2025, the petitioner has joined his service under the aforesaid E-Solutions IT Services Private Limited, full stop. While he was working,
Page 59 and 60, my lords.
ICMR ICMR has issued an office memorandum dated 12/2/2026, whereby a policy has been brought in to engage project staff only for a period maximum of 5 years. 5 years in a single project or across multiple projects with or without break. Full stop. Since the learned counsel submits that since the petitioner has already put in services for more than 11 years, his services is required to be terminated in terms of the aforesaid office memorandum dated 12/2/2026. However, due to a communication dated 21/4/2026, their services were not, the services of the petitioner was not immediately terminated. However, it was extended only for a period of 3 months. Period of 3 months. Being aggrieved with the aforesaid, communication dated 12 to, communication dated
21-4.
Both the communication.
12/2/2026 and 21/4/2026, the petitioner had approached the Central Administrative Tribunal for tribunal. What was the relief, what was the relief you have sought?
Setting aside the impugned
Or-
orders and allow me to continue.
Okay, for setting aside of the impugned orders and allowing the petitioner to continue in the aforesaid job. Full stop.
Page 89.
The learned Central Administrative Tribunal, after hearing the matter, vide its order dated
25-6.
25/6, 25/6, 2026, dismissed, rejected the original application of the petitioner by
Paragraph six.
with the reason that since the petitioner is engaged by an outsourcing agency, which is a private agency and not a governmental organization, the OA is not maintainable, and therefore the same was dismissed on the same was dismissed. Full stop. Next paragraph. Being aggrieved with the aforesaid order of the Central Administrative Tribunal dated 25 dated 20
25/6.
25/6/2026, the petitioner has approached this court. The learned counsel appearing for the petitioner further submits that though the petitioner was lastly engaged with the outsourcing agency, that is respondent number 4, but his service terms and conditions as well as his engagement has been controlled and monitored by ICMR, which is a state agency. Therefore, the ground of rejection of the petition of the original application of the petitioner by the central agency is not at all viable, not at all legal, and therefore the same should be interfered with. Full stop. This court has heard the submissions made by the learned counsel appearing for the petitioner, as well as gone through the materials that have been brought on record in the instant read petition. Full stop. Having found materials to consider having found sufficient materials for further consideration in the instant case, this court issues notice to the respondents returnable in 3 weeks. Full stop. Notice to respondent 1 is dispensed with, since Mr. Chakraborty has put in his appearance. Steps for notice to respondent numbers 2, 3, and 4 should be taken by way of speed post as well as usual course within a period of a week.
The office is open, madam. Try, madam, because vacation.
The offices are open. I mean, offices are open within a period of week, within a 1 week's period. Within 1 week's period. Full stop. In the meantime, till the next returnable date, the order dated 25/6/2026 is hereby
Instead of staying there on a lot.
Status quo.
Status quo of service.
status quo shall be maintained till the in the meantime, status quo shall be maintained till the next returnable date.
As it has been submitted that I'm still working, madam.
Since the petitioner is still working,
Very grateful, madam. to your blessings.
we'll fix a date.
Yes, ma'am.
Next, let the matter be listed on.
Yo,
The order here, please. Uh, 4 weeks. 4 weeks করে দেবো, 4 weeks করে returnable date after 4 weeks returnable date. 29 July. 29 July.
Item two.
So your status quo is will operate till 29 July.
Well, the item two, similar
I'll
size,
see.
I'll just point out the differences.
Hmm.
The name is different. Appointment is 21/01/2019. The appointment order is
Appointment to-
21/01/19. 7 years of continuous service instead of 11. First post was technical assistant research. Item four was statistician.
Okay, that's all.
That's all. And the impugn orders are the same.
Same.
So,
Deeply obliged.
Item three.
Hey,
what happened?
Lordship, in this case, this proceeding has been declared as a foreigner by for your.
Are they the same persons?
Lordship, he is the same person because Lordship, in the earlier proceeding.
Let us go to the earlier order of that uh,
Present order, Lordship, that is on page 36.
and let us go to the earlier order
That is
which
on
was
page-
passed by the uh, mm,
Foreigners Tribunal, not Lakhimpur, Lordship,
hmm, hmm,
Lakhimpur, not Lakhimpur.
what is his name?
Here, Lordship, only difference is Nader Ali, Lordship.
So how can you say that like these are two same
Lordship,
persons?
Can you see that, Lordship, father name and address, Lordship?
No, that cannot be the. I mean that cannot be the.
Only in the present case, Lordship, is
See, he was Nader Ali,
Nader Ali. It's
and Nader Ali and Nosad Ali can be same person.
That Lordship, I have to file a written statement, Lordship. That opportunity can be given because the 36, page 36, Lordship, we sought for a time, Lordship, to procure certain documents, Lordship, and to file the written statement, Lordship.
Why didn't you file these documents there?
That is, Lordship, say misplaced, he has misplaced certain.
No, that
documents, Lordship.
can that be a ground? How much time you have been given?
Only, Lordship, the date, Lordship, next date was fixed as per order, Lordship, 29/9/26, Lordship.
Hmm.
He has appeared on, Lordship, 36/2025, Lordship. The order reflect on page 36.
Ex parte order.
Now, from this order, page 34, how this court this court will find out that this Nader Ali and that this person is the same person?
Lordship, there, Lordship, kind of opinion, Lordship, opinion part, Lordship.
Hmm.
Father, son of Lordship, the opinion part, the view on the finding of.
No,
the
where? Opinion part where? Which page?
Lordship, page 35, Lordship, opinion portion. Part.
Hmm.
Nader Ali, son of late Ahmed Ali.
So
resident
don't you think there can be two persons, two sons can be there?
That Lordship,
Now how this court is going to decide it?
Lordship, family.
See,
tree,
Nader Ali, father of
Not
so and so, and Nausar Ali, father and so, same village, can be two different persons.
Lordship, I have given the Lordship, family tree, Lordship. There is no person named Nader Ali, Lordship, in our family, Lordship.
Then you should have corrected that.
No person, Lordship, Nader Ali. It's
Nader Ali was
proceeding
not
against
declared
this
a-
petitioner,
He was
Lordship.
declared not a foreigner, Nader Ali. But
So Nader Ali is not a foreigner, right? So you were very happy. Well, like, okay, fine. Nader Ali has been given. I am Nosat. I will use this only. Now, when this order has come, you have come to this court.
Lordship thinks is that Lordship only that opportunity, Lordship, I'll file the written statement.
No,
along with the
opportunities
order.
can be given just like that.
Lordship thinks is that Lordship only Lordship, that document Lordship could not procure. That's why Lordship he has taken the time, Lordship. And there is a communication gap between the Lordship, advocates and the proceeding, Lordship.
And what was the urgency that you have filed it? I mean, you have
Because
sought
Lordship now-
permission today.
Lordship, now Lordship, the police is after this petitioner.
But you could have waited for some time. You have been avoiding this for so
Lordship,
many
I'm
days.
ready to contest the
Long
case,
time.
Lordship.
Hmm?
Thinks that Lordship, that,
It was passed in 34/2026.
Nine.
on the, in the month of April, Lordship,
Hmm,
that
then-
certificate copy, Lordship, I obtained on Lordship 16/6/2026.
Correct. So you could have at least waited for some more time there, because in vacation means there are certain urgent matters are supposed to be taken. There are people waiting with urgent matters. Why this matter you have mentioned?
Lordship, thinks is that police is after this petition.
No, that police is always after the, will be after.
Lordship, I am ready to contest this case, Lordship, if opportunity is given, Lordship. It's an expertise opinion, Lord.
Huh? Date of the order. What is the date of the earlier order?
Earlier order, Lordship, it is 9/6/2028, Lord.
Hmm?
Sorry, Lordship, 2019. It's a Lordship,
2008.
2008 order. I have seen it somewhere. Like, where is that?
page 34, Lordship,
9/6/2008, right?
and 35, Lordship, it's bottom, it says 16/6/2009.
So 9/6/2008 order, and you are still not having the order with you. This is your order, you are saying.
Yes, Lordship.
Hmm.
That order, Lordship, he has misplaced, Lordship. He has misplaced, that's why, Lordship.
Then
they-
if you are not diligent, you are not vigilant, then you'll have to suffer.
Yes, Lordship, that is the thing. Only-
You will issue only notice, no stay, nothing. Nothing doing.
On the next day.
One last opportunity can be given. Lordship.
No, let them come back, then we'll on the reopening, we'll consider your thing. Heard Mr. B. Chaudhary, the learned counsel appearing for the petitioner. Also heard you are appearing, or no?
I'm appearing for deputy commissioner.
Oh, Mr. MS so appearing for
Uh,
respondent number
Hi.
5. Respondent number 5. This is the instant writ petition has been filed against the opinion dated 30/4/2026 passed by the Foreigners Tribunal first, Lakhimpur, not Lakhimpur, in Lakhimpur FT in bracket 1 stroke case number 2288 stroke 2011. Full stop. The learned counsel, Mr. B. Chaudhary, learned counsel for the petition submits that the order has been passed. The ex parte has order has been passed. Though the petitioner sought for some time to produce an important document. He was unable to collect the aforesaid important document. Therefore, he could not be present in the court on the day when the order was passed. He submits that the petitioner has already been declared as an Indian by an opinion dated
2008.
Where is the date written?
Find the date.
Lordship,
No,
the first order.
9/6.
Page 30.
9/6/2008 by Foreigners Tribunal, Lakhimpur, not Lakhimpur, in LFT case number 128 stroke 08. In bracket, you can write district number, DIST number 2531 stroke 86. He submits that since the petitioner has already been declared an Indian, he should be given an opportunity to produce the document before the Foreigners Tribunal first, Lakhimpur, which has passed the ex parte order. Let notice be issued to the respondents how will you know? You'll serve the copies. Other respondents?
Others to praise, Lord.
The issue notice returnable in 4 weeks, right? Then the council, the petitioner shall petitioner shall take steps for service of notice by way of speed post within within a week. Within a week. Notice to respondent number.
5.
Respondent number 5 is dispensed with since the learned counsel has appeared. However, the extra copies of the petition shall be served on the respondent number, counsel for respondent number 5 during the course of the day. Let the matter be listed after call.
Lordship, still no coercive action against this petitioner, but Lordship, can you?
No, they are two different persons. We don't know.
That's why he is not appearing. In so many that he is not appearing before the.
Only in the 1 year, Lordship.
No. See, they are two different names altogether. We cannot give you anything as of now.
The names are not similar.
Then Lordship, both the record can be called for Lordship.
Yes, like
that can be
right. The records from the records from F. What was the tribunal?
Okay.
Tribunal number? Records for the records in the instant case from FT Foreigners Tribunal number
Reflected on page 36.
for Foreigners Tribunal number
1.
1 Lakhimpur, not Lakhimpur. In FT 1 case number 2288/2011 registered to call for the records of this case from this court. Okay.
The altogether 12 writ petitions were decided by one judgment, that was SL in 5.
Already one judgment has been
Yes.
passed.
But
So what is there?
Yes, my lord, we are only praying for a similar order, my lord. Because what has happened, my lord, the honorable division bench has extended the time limit to
Yes,
a 45 days period, my lord. And the honorable learned single judge was for the 1 month. And from the date of delivery of that order, it starts from 25/6/2026. The honorable division bench has held that the cutoff period for vacating the land should be 45 days. So if
45 days from the passing of the
That
from
judgment.
25
that judgment.
my lord.
This is the judgment, of the division bench, and this was, my lord, again followed
Hmm.
We have
by-
annexed the earlier order.
by another bench also.
Okay, this was by the division bench
My lord.
and there was another order also.
Yes.
Justice Michael.
My lord, this is the order.
Atar Rahman. I think this order will suffice me.
This order also.
Yes. Because, my lord, we are apprehending that, my lord, in the original appeal order, my lord. was
Okay, we'll pass like this only. I mean, there is no requirement of like we do
Yes.
going into anything.
exactly the same.
Okay, you right. Heard Mr. A.R. Bhuya, the learned senior counsel, assisted by MS so-and-so for the appellants. Also heard Mr. P.N. Goswami, the learned senior counsel and additional AZ for the state of Assam. And MS, who is,
By I Kolita.
assisted by
I Kolita.
I
Kolita.
Colita, and Mrs. J. Hendick for respondent number 3. Respondent number 3. Full stop. The learned counsel appearing for the respective parties have submitted that similar matters have already been decided by a coordinate division bench of this court by judgment and order dated 25/6/2026 passed in
Writ appeal 211.
211.
W 211, 212, 216 and 219 as well as 225 of 2026. Full stop. The learned, the council submits that the aforesaid judgment shall squarely cover the instant writ appeal also. Full stop. In view of in view of the aforesaid submissions, the instant writ appeal is also disposed of in terms of the common judgment dated 25/6/2026. Passed in passed in WA number 211, 212, 216, comma 219 and 225.
Right, definitely.
All right.
No disposal. That reading. Today I am supposed to. What?
I am supposed to give you, my lord.
You're supposed to?
Give you copy, my lord. Yesterday, standing counsel, my lord, was not a binding on my lord.
No, you have taken permission, then you should have given him the copy, then how will, I mean, the hearing will be done?
Today is not possible. Yeah. Today is not possible, Lordship. Just now I have received a copy, Lordship. So after vacation, Lordship.
Matter is not urgent, my lord. On ninth, my lord. No, I mean, we'll put it, I mean, what is the urgency also?
Urgency is there, my lord. There is a direction given, my lord.
There is no urgency, I have gone through a brief. There is no urgency at all. Don't say unnecessarily with frivolous, these things is urgent. There's no urgency. I've gone through it.
If, my lord, in the meantime, my lord, he is appointed, my lord,
No, there's nothing. Only thing is that there is some confusion in the, I mean, there is some, this thing on the, we'll proceed after the vacation. Right, heard Mr. Mr. A.M. Borbia, the learned counsel, appearing for the appellants. Also heard Mr.
T. Thakuria,
C.
Lordship.
Thakoria for
Correspondent
respondent
number 1, 2, 3, and 5.
1, 2, 3, and 5. MSD Deka for
Borman, or respondent
oh,
number,
Bourbon for
respondent number 4.
respondent number 4. Respondent number 4. Mr. Thakuria submits that he has received the copy of the appeal just some time back, and he requires some time to go through the same. In view of the aforesaid submission, let the matter be listed after immediately after the immediately after reopening. No, immediately after reopening of the ensuing summer vacation.
Must oblige.
steps over 6, 7.
Oh, 1 second.
The accused petitioner is in the judicial custody for 87 days.
90 days mandatory.
90-day mandate.
Okay,
Matter released.
okay, we'll take it up.
Oh.
We'll take it up.
May please, Your Lordship. I have also mentioned the matter. He's a doctor petitioner.
Hmm?
Petitioner is a doctor, my lord.
Hmm.
The hospital was closed down, my lord, due to this case, my lord.
Hmm.
One child, my lord, born, my lord, disabled, my lord.
Hmm?
So, one disabled child was born, my lord. So, entire allegations against medical negligence against the petitioner, my lord.
Hmm.
Accordingly, my lord, hospital was closed down, my lord.
Closed down by whom?
But father of the child, my lord.
Father of the child.
Father of the
Can...
child along with my family members, my lord.
So what is to be done?
Case has been registered, my lord. Petitioner is absconding, my lord. So, my lord, patients are suffering, my lord. So, my lord, matter will be dismissed, my lord, payment. If time permits, my lord.
Okay.
Deep down.
DB pleases your lordship. Your lordship, on the DB bench, your lordship, I need one mention on urgent listing, your lordship.
Why
Early-
is this urgent?
Earlier, your lordship, already two occasion, your lordship, that is anticipatory bail and bail application. The petitioner got bail, your lordship, regular bail.
Hmm.
But unfortunately, your lordship, on the pretext of Kamaikha ongoing duty, your lordship, the police investigation officer intentionally delayed it at your lordship at the time, your lordship, when they are going, your lordship, to record their your lordship submissions. At the very moment, your lordship, on the other PS Gorchuk, again arising out of chain of this connection, they are arrested.
Different case.
Your lordship, same, out of same, your lordship, arising out of same, your lordship, only PS is different. First one is Jalukbari, then this one is your
Or
lordship.
different
Goes-
case altogether. I
Your
mean,
lordship.
I mean, different cases have been registered.
No, your lordship, arising out of same issue, your lordship. Nothing has been changed, your lordship. Same sections, everything same, your lordship.
Okay, we'll take it up.
And DPO. of it.
It is item one, also A. 1A,
The PROCTO message. CD.
The POXO matter. Okay, heard, Mr.
A Rahman.
A. Rahman, the learned counsel appearing for the accused applicant, also heard MS SH Bora, the learned APP for the state. This is an application under section 483 of BNSS, praying for granting bail to the accused applicant in connection with South Salmara PS case number 78/2026 26 under sections 126 in bracket 2 stroke 78 bracket 2 stroke 137 bracket 2 stroke 351 bracket 3 stroke 3 bracket 5 of BNS read with section 12 of POXO Act. POXO Act. Full stop. Let notice be issued on respondent number 2 through the office of the learned PP, State of Assam, as per the prevailing notification issued by the Gauhati High Court. Full stop. Notice to respondent number 1 is dispensed with since MS SH Bora has put in her appearance. Call for the CD.
Respondent number 2.
Who's the informant?
Call for the CD. Let the matter be listed on
15, lordship.
15th of July.
Three application. FIR at case 16. In this case, this FIR has been filed by one principal of Gornagar College matter. In the event that one student appeared in his college and show a certificate, and that certificate.
We call for the CD in this matter. Heard,
Documentation.
heard Mr. A.K. Azad, the learned counsel appearing for the accused applicant, also heard MS SH Bora, learned APP for the state. This is an application under section 483 of BNSS, praying for granting bail to the accused applicant in connection with Sorbook PS case number 51/2026 under section 318 in bracket 2 stroke 335 brackets capital B stroke 336 bracket 3 stroke 340 bracket 2 of BNS. All for the CD. Let the matter fixed on 17th of July. Seventeenth.
It's a regular bail application. I am behind the bar for last 33 days. And
You have to wait for some more time.
CD.
Heard Mr. M. Datta, the learned counsel appearing for the accused applicant, also heard MS SH Bora, the learned APP for the state. This is an application under section 483 of BNSS, praying for granting bail to the accused applicant in connection with Demo PS case number 63/2026. Registered under section 103 in bracket 1 of BNS 2023, read with section 25 bracket small a of NDPS Act 1985. Also call for the CD. Let the matter be fixed on 17 July. Call for the CD along with the postmortem report.
Solicited matter. Scan copy of TCM.
Okay, heard Mr. M. Kolita, the learned counsel appearing for the accused applicant, also heard Ms. SH Bora, the learned APE for the state. This is an application under section 483 of BNSS 2023, praying for bail praying for bail of the accused applicant in connection with special POCSO case number 238/2025. 25, registered under section 65(1) in bracket 1 of BNS read with section 4 of POCSO Act. Full stop. Registry to call for the TCR in connection with special POCSO case number 238/2025 from the court of the special judge POCSO from Kamrup Metro. Full stop. Registry to call for the scan copies of the TCR. Oh, yes. Then you write, let notice be issued on the respondent number 2 through the office of the PP as per the prevailing notification of Gauhati High Court. Just let the matter be listed on
28th, 17 was.
17 July.
My lord, the case is in the charge sheet, it's also matter from my lord. The charge sheet, applicant evidence of part has been completed, the complainant, the victim, and another person has been, witness has been taken evidence. And this stage, will application was filed before the learned court of session judge.
So this, trial has been proceeded, trial is going on. So at this stage, why should this court interfere? You wait for some time, trial will be concluded and like judgment will be delivered. Heard Mr. What is your name?
Yes, that's fine.
Heard Mr. S. Thus, the learned counsel appearing for the accused applicant. Also heard MS S.H. Bora, the learned APP for the state. This is an application under 483 of BNSS 2023, praying for bail to the accused applicant in connection with Potasil Ambari PS case number 7/2026, registered under section 87/64 in bracket 2 BNS 2023, read with section 6 of POCSO Act 2012. Full stop. Let notice be issued on respondent number 2 through the office of the learned PP as per the prevailing notification issued by the Gauhati High Court. Full stop. Notice to respondent number 1 is dispensed with as MS S.H. Bora has put in her appearance. Full stop. Registry to call for the TCR, scan copies of the TCR in connection with TCR of where have you written that?
Lordship, page 30, session special case number 32 of the 2020.
Registry to call for, so what is the number?
20 special, session special case 32 of the 2020.
From the court of?
From the court of Lordship, additions, session just come, special just POCSO, Kamrup Metro.
Oh, Metro. Let the matter be listed on?
Lordship, 20th of July.
20th of July. 20th of July.
Obliged.
There is no point making any hurry also because the notice has to be served on respondent number 2. Notice has to be served on respondent number 2. There is no point.
162 days.
Correct. You just wait so that notice is served and they can.
Item 6. Case of 64-1 BNS, earlier 376 case. Case of 64-1 BNS, earlier 376 case.
Can they maybe call for? Election against the rapport.
64-1 BNS, earlier 376.
Your name?
This Virendra Barot.
Your name?
SK Chetri.
SK?
Chetri.
Heard Mr. SK Chetri, the learned counsel appearing for the accused applicant. Also heard Mr. DP Goswami, the learned APP for the state. This is an application under section 483 of BNSS 2023, praying for grant of bail to the accused applicant in connection with Matia PS case number 54/2026 under section 64 in bracket 1/75 bracket 2/79/351 bracket 2 of BNS. charge sheet has been filed in this case? No. Call for the CD. Let the-
21/7.
Huh?
21.
Let the matter be listed on 21/7/2023/26. Yes, Mr. Hmm?
Under 483,
Hmm.
there is a case has been charged under 108, avertment of suicide.
Hmm.
Well, the two accused were here. One person has been granted bail after
Hmm.
the charge sheet, but my bail period was not considered.
You are the main accused,
I'm the husband.
husband,
It is
so main
always
accused.
presumed that I am the,
So-
nothing, my lord, he has committed suicide because first time she came back, second time they have again come and persuaded, parents have sent her and she committed suicide.
Who was the co-accused?
Sister.
Sister.
Scan copy.
Okay, we'll call for the CD.
75, your lordship knows, there is series of judgment. You can-
No, I understand,
One-
understand.
one
And,
to
and I understand, but it's just abatement of suicide. We'll go through the
Trial
CD and
Trial court record.
trial court
Charge sheet.
record, trial court record. Okay, heard Mr. S.C. Biswas, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned APP for the state. This is an application under section 483 of BNSS 2023, paying for granting bail to the accused applicant in connection with sessions case number 43/2026 under section 108/3 of BNS 2023. Full stop. Registry to call for the scan copy of the sessions case number 43 of 2026 from the court of the learned additional session judge Sri Bhumi. Sri Bhumi, full stop. Scan copies, huh? Let the,
On 14,
let the matter be listed on
14,
71.
17th.
It from
It may not come Sri Bhumi, vacation is also there. 17th.
Head of department of.
Hmm. Allegation of mistreatment, sexual assault, or what?
If, what me please to see,
Hmm.
FIR at page 19.
I have seen this.
What if the list of, offence took place on 10/6.
Serious allegations, Mr. KL.
What if me please to see? Yes, what if I understand what if,
Hmm.
but these are the normal allegation. level.
How can it be normal allegation? A girl of it, well, a girl of what? I don't know what was her age. 19 years. Girl of 19 years. She is from Arunachal Pradesh. She is pursuing studies here. Then she went to the teacher to excuse her for her non-appearance in certain certain classes. Then you started asking her to dance, how she dances. All these things are, what kind of things are this? These are the things expected from a teacher?
No, Lordship cannot.
These are allegations that the truth will be found when the cases will be, properly investigated.
Correct, Lordship.
So,
Lordship, in the meantime, the ICCS took up the matter, that
Hmm?
Act. The student is to lose complaint before the ICC.
correct, you have participated there, you have replied there, but in spite of that, you have been suspended.
Yes,
So they have found some certain prima facie materials against you, that is on record. So in those, on the face of those, how this court can consider now?
ICC is taking up the matter, they asked me to file reply. I submitted my, Lord, may please to see page 22.
Hmm?
Page 22 paragraph.
No, I have seen that.
Lordship, at this stage, I can pray that I am ready to cooperate, I am ready to appear before the IO for investigation, Lordship. If your Lordship grant me certain protection, Lordship.
Very serious allegations and and that too against a teacher.
Yes, Lordship. this is
And
not
that too from a known, very renowned university.
the
I
reason
mean,
is-
if this kind of attitude of teachers, then how these universities will be run, how these people from different states
Definitely, Lordship.
will come and study.
The allegation are very serious, Lordship. But whether.
So that is why I'm not inclined at this stage. I mean, we'll call for the CD and we'll see.
I may
I
be
mean,
allowed-
in the reopening only.
I may be allowed to appear before the police, Lordship.
No, that means that I'm giving you relief. I'm saying that I'm not inclined.
No, Lordship, that the circumstances, Lordship has seen the allegation and my reply.
I've seen your reply, but how can you say that like you dance in the
Lordship,
class?
This is absolutely.
This is in your reply. Should I read out? Should I read out your reply?
No, Lordship, yes, Lord.
Oh, see what is there? I also asked the students about their hobbies, how they spend their time, as I was trying to understand the reasons behind their lack of attendance and provide appropriate guidance.
Lordship,
I distinctly remember asking one of the students, I'll tell you. Then I also remember asking one of the students about the hobbies. Then, then I casually asked whether she had any photographs or videos relating to her interest. The students searched through their phones, stated that they did not have any such photographs and videos. In a light-hearted and informal manner, I remarked, okay, then you show me how you dance. Is this the way to do it?
definitely Lordship,
See, this is your own admission.
Lordship.
You have written before the council.
That is the true fact I have stated before the Lordship, furthermore, Lordship, I have a wife and the 5-month-old child also in my life. They are also residing with me in the campus.
Page 31, Lordship.
What is that?
Middle portion, Lordship.
Hmm?
Fifth or sixth line. During the course of investigation, Lordship. May I read, Lordship?
Page?
Page 31.
Hmm.
During the course of investigation.
Where?
Page 31.
The
Yes,
daughter of another accused. he
On
was-
15/6/2026, Narendra Lakra, the superintendent of university campus, took absolute local and safe custody of the accused Dr. Saurabh Chandra by legal Zimma undertaking recorded under Sonapur PSGD number 34 15/6/26, certifying him before the police station whenever called upon, following which he shall be liable as per law. However, when formal orders were issued by the IO to produce the accused Saurabh Chandra for interrogation and arrest, the accused Narendra Lakra intentionally defaulted on his bond and have failed to produce the suspect. As such, the above accused person was, Lordship, he is still absconding. And later part also, Lordship, is
As such, above named accused person was arrested. Who is this?
another person who is taking the
He is my colleague.
colleague.
Lordship.
Hmm?
He is my colleague, Lordship. He
This is-
undertook to produce me for the authority
Hmm.
as and when required.
But he didn't appear.
He was, no, Lordship, I am read, Lordship, because Lordship, please to see paragraph 14, page 32. Paragraph 14.
Yes.
I have perused the case diary and it is reflected in the note in the case diary that on 8:10 p.m. It is clearly mentioned that Saurabh Chandra along with his wife were rescued and brought to the
That I have seen.
Yes, yes.
as protected by French. Lordship, what happened on the alleged incident took place on 10. The FIR was lodged on 16. Then Lordship, in the meantime, ICC.
No, that I understand. But like, this has happened after this.
Lordship.
What Lordship, after ICC, Lordship, after my suspension, this FIR was registered.
And victim statement will be required.
See, I understand one thing that as far as the facts are concerned, when the incident happened, a lot of people get out
Yes.
his house and police came and rescued them.
Yes.
Till that it is perfectly fine. He had to be rescued and he was rescued and thereafter he was given the custody of this person,
Yes.
this Lakra or somebody. But this Lakra person has defaulted
Yes, Lordship.
in spite of giving a bond.
Because Lordship, the local people around the university.
No, that happened prior to that.
This is that.
That happened prior to that.
14 law.
No, Mr. I mean, in the reopening, we'll see. At this stage now, difficult. Heard Mr. S.C. Kayal, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned APP for the state. This is an application under section 482 of BNSS 2023, praying for granting anticipatory bail to the accused applicant in connection with Sonapur PS case number 0067 of 2026 under section 75 in bracket 2. Stroke 76, stroke 61, bracket 2, stroke 3, bracket 5, stroke 249, bracket small c of BNS 2023. The learned counsel, Mr. S.C. Kayal, the learned counsel appearing for the accused applicant, submits that accused applicant is a professor, is a teacher, is an assistant.
Department of Public Administration.
He is the head of Department of Public Administrative Department of Don Bosco University, and there were certain allegations against him made by one of the students of the aforesaid university, and thereafter the accused applicant was suspended. Full stop. He submits that accused applicant had to be rescued from the university due to the volatile situation in the university, and at present, the accused applicant is is having serious apprehension of his uh, uh, arrest. If further submits that the accused applicant has participated before the ICC, before the internal complaint committee at Don Bosco School, and his case, and he has already replied to the so cause notice issued by the university. Full stop. Since he has been participating and cooperating with the investigation, cooperating with the inquiry that has been conducted by the Don Bosco University, and he is willing to cooperate with the investigation, he should be allowed to go on pre-arrest bail. Full stop. Let him go. Let him go, and I mean, we are giving interim. Let's see what comes in the CD, and
I'll appear on
and all these CDs. I mean, let's see what is there in the CD. Full stop. That Mr. DP Goswami, the learned APP, on the other hand, submits that on the other hand, submits that the accused applicant is not cooperating with the investigation, as can be reflected, as the same is reflected in the order dated 17/6/2026, passed by the sub-divisional judicial magistrate and dash 1/Kamrup Guwahati. Full stop. He submits that though the accused applicant was given the custody of one Mr.
Narendra Lakra.
Lakra. What is he? Who is he?
Is a university staff.
Huh? Narendra Lakra, a staff of the Don Bosco University,
Superintendent of University campus.
superintendent of Don Bosco University campus, and with a bond that he shall produce the accused applicant whenever he is required. Full stop. Required, comma. However, the same was not done by him in spite of formal orders issued by the IO for his production and interrogation. Full stop. In view of the aforesaid Narendra Lakra has already been arrested. Taking into account all the aforesaid facts, the learned APP opposes the bail, opposes the prayer for pre-arrest bail of the accused applicant. Full stop. This court, after hearing the submissions made by the counsel appearing for the respective parties, and upon consideration of the materials that have been annexed with the instant application, is of the considered view that at this stage, the accused applicant should be granted interim pre-arrest bail on his submission of a bail bond of rupees 1 lakh with two securities of like amount to the satisfaction of the arresting authority, subject to the following conditions. Full stop. So subject to the following conditions. Number one, that the accused applicant shall appear before the investigating officer within a period of 7 days of passing of this order. Number two, the accused applicant shall fully cooperate with the investigation and make himself available before the IO as and when required. Full stop. Next, you write, the accused applicant shall not leave the jurisdiction, shall not leave the,
University campus.
the university campus without the permission of the sub-divisional judicial magistrate, that's Kamrup Metro. Full stop. That will do. I have, he will not leave without his permission, and let him cooperate with the investigation. Then you write, call for the CD let the matter be listed
22-7.
22/7. We will say.
May I please, Sir Lordship? Lordship, in this bail lordship, the FIR is at page 17, the Anand Lordship. May I read?
You read the, you have a translated version?
Yes.
Where is that?
Page 10.
Yes. Page 10 is there.
So you have cheated 7,50,000 rupees, stating that you are a Kabiraz.
No.
Hmm?
So far the allegation is.
You stayed with the, stayed in the house, then like this, this,
No, I'm not.
this disabled
I'm not
boy.
that person. I'm Ramzan Ali Lordship.
You are Ramzan Ali, your acquaintance, in your account, the money was transferred, isn't it?
Yes.
I have read it, mister.
Okay,
So don't tell me ki like
Lordship,
this
for
and
a
that.
moment,
Huh?
For a moment.
For a moment, what?
Ramzan Ali Lordship.
Ramzan Ali is an acquaintance of this person and money has been transferred to his account. You are saying that he is a friend of mine. That's why I have allowed him. And that's why this court should allow you to go on
No,
privacy.
Lordship.
No.
Lordship, in the FIR Lordship,
Hmm.
if we go through the FIR Lordship, it is especially mentioned Lordship that the Asadul Lordship, functionally managed Asadul Lordship. Asadul stayed 3 days in the residence of Lordship, the informant Lordship. There is no single sound about Ramzan Ali Lordship.
Yeah, Ramzan Ali was not there. I'm not saying Ramzan Ali
Yes.
was there.
Now Lordship, the amount Lordship transferred to Ramzan Ali Lordship. Ramzan Ali never visited to Sharfanguri Lordship.
Not required.
Yes, Lordship. So there is no communication, there is no single communication.
That only communication is that
Yeah,
you have deposited the money.
that
Your
amount-
communication is that only.
that
That
amount
one.
is-
You see, your communication is that only that you have deposited the money. That is your communication. And no communication is
No, no,
required.
I have not communicated.
No, I'm
Lordship.
rejecting this. Heard, mister?
Lordship, kindly
I am
put it-
rejecting this. Heard, mister?
Lordship,
Heard, mister?
Lordship.
What is your name? Tell me.
J. Islam, Lordship.
Heard, Mr. J. Islam.
Subsequent incident is there, Lordship.
What?
Lordship, informant has visited Oran police station, Lordship. And she has collected the all address, Lordship, through the mobile number and account number, Lordship. After visiting the police station, Lordship, informant given complaint, Lordship, the IC Orang police station communicated the accused Ramzan Ali, Lordship. Ramzan Ali appeared and he has all details, he has mentioned all everything, Lordship. And then, Lordship, Ramzan Ali helped them to recover the money from the other accused, Lordship, basically the Asadul, Lordship. 2 lakhs amount has been already recovered, Lordship. Lordship, that part, Lordship, I have already stated that Ramzan, what is the connection of?
So when you got caught,
Yes.
you tried to help them out, recover some money.
Oh, Lordship,
And is it going to wipe out that LA's
Lordship,
commission of
Lordship,
offense
for a
by you?
moment, if somebody-
I've heard you enough. Now, I'm not inclined you go to some other court.
Lordship, if-
Heard,
if-
Mr.
if
Yeah.
any
No,
person
I have gone
lends
through it.
money to me.
I have already gone through your petition. I know what is happening, what is not happening. I have heard your submissions. If you want to make more submissions, you can make it. There is no difficulties. I'm here to hear you. But you make something which is substantial. Huh? No, CD is not required in this case. CD is not at all required in this case. CD is not required. I'm not inclined to give you anyway. You keep on cheating people like this. No, cannot.
My part is, nothing is there.
Your party is that your account has been utilized. Why you have allowed somebody else to utilize their account? And you are saying that he is a friend of yours. So you should know who is a good friend, who is a bad friend.
He is not my friend.
Then-
My neighbor.
Then why? Then your neighbor, you will give your account number to some neighbor.
Yes.
Huh? Don't say all these things. Heard Mr. J. Islam, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, the learned APP for the state. This is an application under section 482 of BNSS 2023, praying for granting anticipatory bail to the accused applicant in
That part will clear everything.
not, I'm not, see,
Victim statement
see,
will be-
Mr. Islam, whenever we think that CD is required,
But
we all,
the-
whenever we think that CD is required, we always call for it. Have you seen that the CD is not called in Calda cases? But
in
this
the
case,
informant
this
statement, it
cause,
will be
this
clear
case,
whether
this
my
case,
connection is
this
there.
case, CD is not required. CD is not required. In this case, your involvement is, it's apparent. In connection with Serfanguri Police Station, case number 02/2026 under section 318 in bracket 4/299/64/62/3 bracket 5 of BNS, full stop. The allegations as narrated in the FIR lodged by one Sangeeta logbook, Sangeeta logbook, inter alia, that the FIR laws before Serfanguri police station, before Serfanguri police station on 2012-2025, inter alia, is that
Incident of 2024.
is that her son Raju Rava, aged about 7 years, could not walk for last 4-5 months, and to cure her son, she was looking for a traditional healer, Kabiraz, semicolon, that on last 9/7/2024, one Samser Ali came to her house and told her that he can arrange a good Kabiraz to cure her son, semicolon, that accordingly he brought one Asadul Haq, representing Asadul Haq, who himself represented as a holy man, Sadhu, in bracket Sadhu, to her, and Asadul Haq and the aforesaid Asadul Haq stayed for 3 days in the house of the informant and performed certain traditional rituals and prayers. It was semicolon, that they introduced themselves as Hindu in front of the informant, and in the hope of cure of her son, she provided sufficient amount as demanded by them, semicolon. Accordingly, she paid an amount of 7,50,000 altogether to the accused person, to the aforesaid Asadul Haq, semicolon. However, after spending considerable amount of money and spending sufficient time, since the son of the informant was not cured, she got suspicious and she found out that in fact the accused applicants belong to the evidence, found out that the aforesaid Asadul Haq and his accomplice were were not from the Hindu as they have claimed, as Hindu Sadhu Baba, but they belong to Muslim community, full stop. In view of the it was also alleged that during their stay, the aforesaid Asadul, who tried to rape them?
There is a specific
Hmm?
single line.
Single line. What
They-
is
they-
what is written there?
They also attempt to commit.
They also-
No, in Assamese vernacular.
Yes, Lordship. Lordship.
ইহঁতে মোৰ ঘৰত 3 দিন থকাৰ সময়ত ধৰ্ষণ কৰিব বিচাৰিছিল।
It was also alleged that during their stay, the aforesaid Asadul and his accomplice tried to rape her also. After they went off, the informant with her lot of efforts and visiting them several times, she could the aforesaid Asadul and his accomplice returned 1,50,000 to the informant and transferred another rupees 50,000 through online. However, the remaining 5,50,000 rupees is yet to be paid by the aforesaid Asadul and his accomplice. In view of the aforesaid, in view of the aforesaid filing of the FIR, in view of the aforesaid FIR, the police registered the Sarfanguri Police Station case number 2/2026 under the aforementioned sections. The police accordingly arrested the aforesaid Asadul Haq and Samsaid Ali. Full stop. During the investigation, it was found that how much money was deposited in your account?
2,71,000.
It was found that about 2,71,000 was transferred to the account of the accused applicant by the aforesaid two accused persons. Full stop. Mr. J. Islam, the learned counsel, Mr. J. Islam, the learned counsel appearing for the accused applicant submits that the accused applicant is a neighbor of the accused, the main accused Asadul Haq, and since he requested for the account, he has given the account, but he is no way involved in the aforesaid case aforesaid case as.
Asadul is not neighbor, Lordship.
Oh.
Brother-in-law Asadul is the neighbor.
Okay, brother-in-law,
Asadul, different.
some is that the brother-in-law of Asadul is a neighbor of is a neighbor, and and on their request, he has given his account number only to transfer the money, and he is no way linked to the alleged offense as narrated in the FIR. He submits that he is apprehending arrest, and in the event of apprehending arrest, and he will cooperate with the investigation in the instant case. The learned next para. On the other hand, Mr. D.P. Goswami, the learned KPP, opposes the prayer of the bail. He submits that the accused applicant is also an accomplice of the arrested accused persons, and therefore his account has been utilized by them. Therefore, utilized by them. He opposes the bail application, utilized by them. Full stop. Next para. After hearing the counsel appearing for the respective parties, and on perusal of the materials that have been brought on record in the instant AB application, this court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant AB application is rejected.
May I lordship, please? May I lordship, please?
Warranty limited.
Yes.
May I, no.
One second, Mr. Datta. One second.
Yes, yes.
I had some connection with warranty long time back, around 20 years back.
This is a new issue, my lord. We have already left the garden. The warrant has sold out the garden, my lord. No more in the picture.
So there is no issue, no?
No issue, my lord. Correct. No issue.
Okay. Okay, we can go ahead.
No, yes, my lord. There is a reference, my lord, on the issue that we discontinued the pensionary benefit to the retired employees due to the economic and financial burdens upon the penny.
Okay,
Before this,
can you give me a little bit of summary of the facts? What has happened exactly?
yes, that's this. Then, Lordship, we discontinued the pensionary benefit to the retired employees. Then the disputes come in, and the appropriate government.
You are warranty limited, right?
My lord, we have 4 gardens in operation. We have 4 gardens.
No, warranty.
4 gardens.
Warranty is the company, and they have 4 gardens in the Upper Assam.
Operation.
Correct.
My
Then,
lord. And we in January 2003, by way of an agreement to say the assets and the movable and immovable properties to the petitioner of the next case, my lord, item number 11, Dhanshiri and Maduting. Then during the before the Dhanshiri and Maduting Tea Company Private Limited, the petitioner of the next item. Now what happened, my lord? Before transferring,
you're not audible. Your connection is not good.
May I audible now?
It's coming in
May
a
I
very,
audible now?
yeah, it's coming in a very disturbed way. It cannot be. I mean, it is we are having difficulties to understand.
My lord, it's a difficulties. May I audible now, my lord?
Honestly, intermittently you are.
May I audible now, my lord?
Yes, tell me. Yes, go ahead.
Now in 2022, we withdraw the pensionary benefit to the retired employees. And a reference was sent by the appropriate government to the industrial tribunal for adjudication.
Dispute
Lordship,
happened.
kindly have a look at page 2.
The dispute happened for what? You entered into an agreement with 2 tea estates, for 2 tea estates, right? The Dhansiri and other
4
one?
tea estate, my lord. Maduting.
Yes.
What happened? The warranty in the
Let Mr. Deka brief us a bit.
warranty limited have 4 gardens in the Upper Assam.
Okay.
So earlier, there is the agreement between workmen regarding payment of some retirement benefit for workmen who has already retired. So after as the garden is regarding losses, so therefore warranty limited stop the pensionary benefit given to the retired employee. So therefore retired employees agitate the grievances before the government, and accordingly government referred the matter before the tribunal for deciding only 2 questions. First question, whether the management's unilateral decision to discontinue pensionary benefit to retired staff was valid. Next, whether retired staff of Warranty Limited were entitled to continue pensionary benefit. First is whether decision is valid or whether the
Mr. Doctor, I think
Yes, madam.
there is some connection problem. You can do one thing, like you have an option. I'm just saying, this matter can be listed some other date also if you want to come personally and present the case.
Next date
Or,
is to move.
huh?
Problem is the next date is to move.
Next date means?
Tomorrow is the next date, my lord, and already the tribunal has issued an execution proceeding.
Then why you have approached so late? That's your fault.
My lord, the execution proceeding we had received the day before yesterday, my lord.
I cannot understand anything what you are saying.
Let the Mr. Daka has explained, my lord. Let the Daka kindly hear Mr.
Okay.
Daka.
kindly come to the, in my petition.
So those two issues were referred to the industrial tribunal.
To industrial
Then
tribunal.
industrial tribunal, what industrial tribunal
Then
has done?
Industrial tribunal issued notice to the Warranty Limited.
Hmm.
Warranty Limited appeared and filed their written statement
Hmm.
stating that on January
Hmm.
2023,
Hmm.
they have entered into an agreement with the petitioner of item number 11, Moduting and Dhansiri tea state
Hmm.
for selling those tea state, and as per the said agreement, the management has been handed over to those petitioners.
Hmm.
So therefore, they are necessary party to the instant proceeding.
Hmm.
So after filing of the written statement, this Warranty Limited also filed an implement application before the tribunal stating that since the management has already been handed over to Dhansiri Tea State, so therefore they are necessary parties to the instant proceeding for decide the issues involved. The workman did not.
No, but if you have already sold them,
Yes.
sold.
But there is an agreement for sale because there is a step-by-step process. Because first movable properties has been transferred, then immovable properties, their permission from the government is required. So therefore, what happened? We file an application stating that this Moduting tea state is also a necessary party because now the management has been handed over to them. And as per the agreement, cut off.
Now, as per the agreement, when it should have been totally transferred.
Yes, management has been totally transferred.
No, that's why if management has been transferred,
Yes.
for full completion of the transfer process,
Yes,
was there any date?
because there is a cut-off date.
No, what was the cutoff date?
Cut-off date is December 2023.
So what happened then? If December 2023 was the cutoff date,
Cut-off date.
then it is deemed that like all these properties have been transferred to them.
Yes.
Correct.
Yes.
Now then, why warranty has come into the picture?
No, because this management, original this reference was initiated prior to that.
When?
Because in
Na-
2000,
Reference was when?
a reference is of 2022.
And
Because we issued the notice discontinuing the retirement dues to the employees in 2022. then-
when you were in the helm of the affairs.
Yes.
Hmm.
So therefore, ultimately, tribunal has implemented the Moduting tea state as a party to the said proceeding.
In the reference.
Yes.
Hmm.
And both the petitioners have filed their written statement
Hmm.
also.
Hmm.
So thereafter, suddenly, the presiding officer industrial tribunal asked the petitioners, both the petitioners, to produce some document which has no relevancy in deciding the reference at all. So he has called for a board resolution, how you have entered into an agreement, agreement is the same agreement, then agreement already they have produced. So lease is whether the decision to discontinue the pension is valid or not. If then whether they are entitled to the pension or not. These two issues. So
No, but issue of transfer was relevant, and accordingly,
yes,
you have brought that thing to the notice of the
yes,
presiding officer, saying that we have already transferred.
Yes.
So that those have been transferred.
yes,
Now the issue involved with them also because already management has been changed.
change.
But before changing of the management, you have taken a policy decision that you are not going to give pension to the retired officials, right?
Yes,
Retired officials. So now they have asked for certain documents,
yes,
presiding officer.
yes.
Whether you have given those documents or not.
Already we have whatever agreements we have entered into,
Hmm.
we have brought before the tribunal,
Hmm.
both the parties. Then tribunal started to ask how you can go sold a tea state like in a manner by virtue of agreement. So therefore directed the Central Investigation Agency to investigate against the petitioners by by alleging that the said transaction is a fraud transaction. So beyond the scope, he has traveled beyond the scope of the reference. And ultimately he has given certain direction to the SPIF, Special Investigation
Okay, let us go to that impugned order.
Impugned judgment law. Impugned at Annexure 10, page 215 in my petition.
Please.
Item number 11, I am arguing logic. From logic in item number 10.
Yes, page.
Page is 215, annexure 10. Relief and start at lordship
2120
215.
215.
215. This all piece that he separately discussed. 226 is start from the garden wise finding.
Hmm?
226, paragraph 14 of the order.
226.
Yes.
Yes.
Merit, paragraph 14.
So out here, how many tea states were there? Four.
4 tea states.
Huh?
4 tea states.
And in this petition, who are there?
In the warranty is the original owner, Mr. Senior Counsel.
And here, Dhansiri and
Moduting.
Modhuting.
I am
Now,
I am appearing.
and it is Duamara or something that hasn't come.
4 gardens,
Hmm?
3 gardens purchased by the Tunseri 2 step
Hmm.
and 1 garden by Moduting,
Okay.
sister concern company.
Okay. So all three gardens are bought by these two tea companies.
Yes,
only.
4, yes.
Okay. So,
The Duamara tea state.
hmm.
The sale of Duamara tea state is said to have been effectuated by virtue of the document entitled Agreement for Sale Duamara tea state being serial number so and so agreement with the date of registration so and so at officer so and so so and so. Perusal of this document shows that it is Havendam is identical with the agreement for sale of Devhali tea state discussed above, with the exception that the due to typographical error, paragraph number has been become split into paragraph 2, 3, 4, 5. And what is contained in paragraph 2 onward is the document relating to Devhal tea states has been numbered as paragraph 6 onward is the document relating to Duamara tea state. The distinction between the two lists is sale consideration which has been shown as so and so so and so. Clearly, all the detailed observation, discussion, applicable laws and the statutory value of this agreement for sale are the same as those in the case of Devhali tea state. It is also seen that the stamp duty paid rupees 5,000 because agreement for equal 5,000 as per the present and a registration fee of rupees so and so so and so so and so. Then Hatimara he has discussed. Then Tarati is discussed. Then finding at page 21, 229, paragraph 21. Viewed as above, all the 4 agreements for sale discussed above are hereby held to be ineffective. He has go beyond like this civil code, illegal and same document purportedly fraudulently. The ignorance of law cannot be taken as excuse for justifying commission of an illegal act or omission. The Warranty Limited, the Thunseri and the Industries and the Moduting Limited are juristic person, companies incorporated under the Companies Act 1956 and continuing as such under the Companies Act 2013. The 4 agreement for sale submitted by the said companies were jointly prepared by them, which make their collusion apparent and blatant. The fallout of this 4 same document is that the workmen of Devhal tea state, Duamara tea state, Hatimara tea state, Tara tea state cannot have an effective remedy against their employers in the event the employers infringe their right as employee. This is also wrong because the agreement there is stipulate what will happen by virtue of transfer. This is so as because the same document have been effect the confusing the employees of these tea states as to actually is the legal employer and who is to be litigated against each in case of infringements of the right or in the event of any they are made victim of unfair labor practices. Further, this also shows that the companies involved have acted in derogation of the relevant provision of the Companies Act 2013 by effectuating the purported transfer of assets and liabilities in unlawful manner. The failure of these documents submitting the resolutions of the transfer and the transferee companies enjoined in section 378Z of the Companies Act indicate that there is no such resolution in the general meeting of the respective company. The reference to their dispute in this case was made on 3/11/2022 and the 4 agreement for sale creating an aura of fictitious sale were executed on so and so and registered on so and so. This is indicative of the fact that the reference of this industrial dispute might have been a trigger of those transactions. Further, the 4 documents create a packet of being agreements for sale, whereas the wording of the document show that the intention of the transferor and transferee companies were to execute and register sale deeds by paying meager value of stamp duty of rupees 5,000 is incorrect statement. This is the agreement for sale, for that 5,000 is required. For sale deed, there is different. Government has to accord permission. In each case, and registration fee of 1,000 of rupees or rupees 2,000, so and so in each of the cases. It is not possible to envisage that the aforementioned act of the involvement companies were not result of conspiracies to run the companies in an unlawful manner for the perpetration of wrong committed or to be committed against the employees. Further notable fact is that the senior sub-registrar Tinsuki was duty bound to examine the content of the aforesaid document, and it must be inferred that he did read those documents, understood their correct legal import, meaning thereby that the document were in fact intended to effectuate sales of immovable properties and intangible properties of huge value, and still pretended to allow the document to be seen and understood a mere agreement for sale. This point to no other possibility than that the said senior sub-registrar Tinsuki had joined hand with the aforementioned three companies for depriving the state of its legitimate efficacy in recovering the stamp duties and registration fees. That is also not correct. I am showing the provision of the agreement. This clearly enabled the larger conspiracies of the three companies, namely Warranty Limited, Dhunseri Limited Industries, and Moduting Limited, to run their affairs against the mandate of the Companies Act for the purpose of defrauding their employees to take effect, which legally speaking, according to the section 120B of the Indian Penal Code, which has then enforced, means that the senior sub-registrar Tinsuki was also a part of the said larger conspiracy of the transferor and transferee companies. The above indicate that the companies aforementioned and the then sub-registrar Tinsukia were involved of the fraud serious nature, and conclude that the investigation under section of the companies which has followed. Then he quoted the provisions of the Investigation Act. Then page 235 is finding. What's it got?
Yes.
Para 26. The case record revealed that the notification of reference being so and so dated 12/12/2022 had led to registration of this reference case on so and so, despite the mandate of Rule 12(1) of the Assam Industrial Dispute Rule. The government, through its Secretary Labour Welfare Department, had not sent the application by the party to this list, which has first approached it, so as to enable the tribunal to know about the earliest point of time when the dispute in hand had found its genesis. As such, the tribunal is not in a position to know about the point of time except the date of issue of notification of reference. The proceeding was initiated on the 21/12/2020 and 26/4/2010 is the first date when Warranty Limited had entered appearance for the first time and sought time further time to its pleadings. Then he written about the proceeding when the WS was filed and when the this impediment was filed.
Read out.
Enter.
Now read from there. Continue
Right.
reading.
This proceeding was intimated on then next line. After 4 more adjournment, it is submitted in the written statement on 3/7/2023. On 17/7/2020, when the case was listed for evidence, this company submitted inter alia petition for time to raise the issue of maintainability of this proceeding against it, instead of straightaway submitting a petition raising the issue of maintainability. Realizing that it had overlooked framing of issues in the case, this tribunal had framed issues on that date, listing the case for evidence on 1/8/2023, when the workman submitted affidavit of evidence of these 3 witnesses. Warranty Limited did not file their petition. It had sought for time. On 23/8/2020, it has submitted a petition seeking time to submit the petition for taking up the issue of maintainability of the matter against it. On the same day, it is also prayed for implement of the Dhunseri Tea State and the Limited and the Moduting Tea Limited, on the ground that these 2 companies have stepped into the shoes of Warranty Limited. However, it is seen that on the said date, the regular presiding officer had been transferred. The case was then listed on 39/2023, when Warranty Limited took further time to submit a petition for raising issue of maintainability. Similar petition was submitted on 20/11/2023, and ultimately it is submitted the proposed petition on 9/1/2024. On 5/2/2024, Warranty Limited again took adjournment However, since the workman had sought time to submit objection against the petition for maintainability, the case was listed on 13/2/2024 when the objection was submitted, and 11/3/2024 was fixed for hearing, which could not take place because the absence of the management. On 30/4/2024, adjournment was again granted at the instance of the warranty limited on 3/6/2024. Matter was heard and warranty limited took the stand that the implement of Dhunseri Tea Estate and Industries Limited and Moduting Tea Estate Limited was the only issue, meaning thereby that it had abandoned the issue of maintainability. Both the written statement and the petition number so-and-so dated so-and-so by warranty limited had taken the plea that the concerned tea estate whose pensioners before this tribunal had been transferred to aforesaid two other companies by way of agreement for sale dated 18/1/2023. On concession for the workman side, however, Dhunseri Tea Limited and Industries Limited and Moduting Tea Limited were implicated in this case, and the warranty limited was directed to take step for notice for their implement. 2 dates were taken for taking.
Okay, this you can skip then.
Then Lordship, this is the about the proceeding. Lordship.
Then 27 you read.
27 Lordship. The
Yeah.
above shows repeated disregard of the order of this tribunal.
Okay.
Tribunal and egregious delaying tactics on the part of the warranty limited, Dhunseri Tea and Industries Limited and Moduting Tea Limited. Noteworthy is that this dispute related to retired pensioner allegedly deprived of their pensionary benefit, and they have been being harassed for the last about 3 years. If the time of genesis of this dispute before the government is not taken into account, instead of filing petition raising issue of maintainability straightway, as has been stated above, warranty limited had been submitting petitions seeking time to submit the petition which could have been done in one shoot. Similarly, the newly implicated companies also kept delaying the matter by not submitting their document as directed by this tribunal. As the end of all this exercise, it has been found that no legal sale has been taken place. Needless to say, the conduct of these 3 companies have been in flagrant disregard of the plight of the retired pensioner and even the direction given by this tribunal time and again. This tribunal takes strong exception to the unbecoming conduct of 3 companies and their tactics of delaying, depriving the retired pensioner of their legitimate dues. Rather, Warranty Limited, Dhunseri Tea and Industries Limited and Moduting Tea Limited have been acting in chaos with one another in their evil design to mislead this tribunal and cause miscarriage of justice by so acting to fulfill their design, while investigating, if any, by the SFIU will take care of the criminal aspect of the matter as is being referred to it. This tribunal deem it appropriate to impose exemplary cost on the 3 companies. Each of them shall therefore pay a cost of ₹5 lakhs in the form of demand draft drawn in favor of the presiding officer, Industrial Tribunal Dibrugarh. The said money shall pending disposal of this case be paid to the aggrieved pensioner, detail of which shall be submitted before the tribunal by the concerned trade union with the supporting document establishing their identities, proof of their engagement with Warranty Limited in the concerned 4 tea estate, and their bank account details so as to enable this tribunal to decide or payment of disbursement of their cost realized. The cost imposed by virtue of this order shall be in addition to the cost, if any, already imposed in this case, since it had been held by this tribunal that the Warranty Limited has failed to in showing that any illegally valid and enforceable sale of or 4 estate, namely Gauhati Tea Estate, Duamara Tea Estate, Hatimara Tea Estate, and Tara Tea Estate, has taken place, and that the 4 number of agreement for sale of those tea estates submitted in this case are same and invalid documents. Dhunseri Tea and Industries Limited and Moduting Tea Limited cannot be considered to have stepped into the shoe of Warranty Limited, and therefore the names of Dhunseri and Limited and Moduting Tea Limited are struck off from the array of the implicated employees' management. Consequently, it is directed that the question referred to this tribunal by the state of Assam shall be adjudicated in reference to Warranty Limited. For proceeding further in this case, parties hereto are directed to submit all the original documents in their power and possession, relevant matters under adjudication by enumerating them in a list with set of copies, therefore for the rival side on so-and-so, so-and-so. Interestingly, yesterday, the petitioner has received a notice. This tribunal, Sumutu registered a money execution case, Industrial Tribunal, registered a money
No,
execution.
that's a different thing. That's a different thing.
Yes.
But now this case is what has happened to the reference from the last paragraphs. Further proceeding further in this case, parties hereto are directed to submit all original documents
Yes, yes,
in their power and possession.
yes, not hearing not take place,
Hearing hasn't taken place.
not
So
all.
you have come against this order.
Against this order.
So I mean, what the ultimately tribunal says that there was no sale at all.
Yes,
So if there is no sale, warranty is still there. Why
Yes.
this parties should be made, I mean, this Modu thing or the Dhansiri should
no,
be made
here,
parties?
here is certain reason.
No, no, he said, see,
Yeah.
he said that there was only an agreement to sell.
Yes,
And for agreement to sale, you have paid the necessary stamp fees,
yes,
whatever.
yes,
So there, the sale has not happened as yet.
yes,
So if sale has not happened as yet,
Yes.
where is the question of making these two people, these two other two persons, Dhansiri and Moduting,
Yes.
a party in the
Yes.
instant case?
Yes.
So they have rejected, they have stuck
Yes.
off those names.
yes,
The court has realized
Yes.
they have gone through because the presiding officer keeps on changing.
yes.
So what is the wrong in that?
First wrong is that he cannot commented validity of an agreement for sale by a
He
independent
is
tribunal.
not commenting about that. Maybe he is commenting on the validity, but
Yes.
but there is an agreement to sell. There is no sale at all.
He said that this is the same document.
Hmm.
He cannot comment it. He's not he has no power to the civil.
He,
court.
the court cannot keep their eyes closed when the documents are there
that
before the
is
close.
Because why they are made parties, this Thunseri.
Now, see, first of all, warranty is the party when where warranty was the company which was in the helm of affairs when the policy
Yes.
was brought in.
Yes,
Then what was the need of warranty to implement this Dhansiri and Moduting tea estate? First of all,
yes,
you'll have to answer this.
yes,
Why you have brought in these two parties?
yes.
Because these two parties are only managing maybe, but the sale has not sale is not concluded as yet.
Yes.
So now you cannot say that they have come into your shoes
Yes.
because sale has not completed as yet. They are only managing parties.
Yes.
So for managing, if you engage somebody as a manager for a time being,
Yes.
till the conclusion of the deal,
Yes.
the deal is not concluded as yet. So there is no necessity of bringing them.
Yes.
So you have brought them. This was why you have done so.
Because we have done so as per the registered agreement. So there is a effective date of 1st of January 2023.
Correct.
So here the question has to be decided by the tribunal is whether the management means decision of the warranty limited to stop the pensionary benefit to the retired employee is valid or not.
That I understood.
Yes.
But why you have brought in these two
Because
parties?
Because we have brought that there is a in between as per the agreement, there is a cutoff date and who will pay the gratuity and pensionary benefit. So that has been clearly reflected in the registered document.
So what is that?
So that is one of the similar agreement, page 27. First clause.
Page 27.
27, this is the agreement, first agreement. All are identical agreement.
Correct. Page 27. What is that?
Clause number 1. The purchaser has agreed to acquire and the vendor has agreed to transfer his right title, beneficial interest, including leasehold interest, subject to the terms and conditions and provision hereinafter contained, free from all encumbrances with effect from 1st of January 2023. That is the effective date. So second, Lordship,
Effective date of what?
effective date of transfer of the movable and immovable properties. All that the tea estate known as Deohal Tea Estate situated in the district of Tinsukia in the state of Assam. So and so and
So this subject to the terms and conditions provisions thereafter contained free from all encumbrances
Yes.
with effect from 1st January 2023.
So
That means by 1st January 2023 you will have the sale agreement ready.
ready.
Ready. So have you done it?
No. This is the agreement. So
This
liability
this is
for
this
cut off this for
see, this is an agreement to sale.
yes,
This is agreement for sale.
yes.
So agreement for sale, you'll have to complete the
Yes,
whole
for
thing.
complete, for
Hmm.
this state.
So
permission has to
so
take-
agreement to sale, then you'll have to make a sale agreement.
Yeah,
So sale agreement you haven't done as yet.
this is the sale agreement.
How can this be a sale agreement?
This is the sale agreement, Lord. Agreement for sale of Gauhati.
This is agreement for sale. There are two things. There is
Yes.
one sale agreement and one is agreement to
Sale
sale.
deed. No, sale deed.
Sale deed, sorry, sale deed.
For
Yes.
sale deed.
Sale agreement, agreement to sale, you can say one thing.
Yes.
And the sale deed. So say, have you made the sale deed?
No, sale deed, there is a procedure
Hmm.
that we have applied for government, government will.
So that is why,
So after the, everything is over, government will fix the stamp fee and it is communicated to the deputy.
Correct.
commissioner, then sale deed will happen.
That I understood. So now by bringing in this effective date,
Then
effective
also-
date means,
Page
the
31.
effective date means,
Effective date means the prior to January 2023,
hmm,
warranty will be liable. The after 1st of January 2020.
without being sale deed.
Because management has been transferred.
So what?
So if sale deed is required for the
Management is,
property only.
management, yeah, property only.
Yes.
That is what, the management change, but management changes, that doesn't make any
Yes.
difference.
Then gratuity, why there gratuity?
18th
loss?
January
Then it is here.
18 January 2023,
Yes,
you have execute, this is the execution date.
yes,
And you are saying 18 January 2023, and you are saying that 1st of January 2023 will be the effective date.
yes.
Effective date of what?
Effective date of the terms and conditions
Of this
of the
agreement. Yes, of this agreement. Not the date when you will complete the whole
No.
whole transaction. No. So this agreement is still effective
Yes.
because sale deed hasn't been done as yet.
Yes,
Huh?
yes,
Correct. So till the sale deed is not done,
yes.
that the property has not been transferred.
No.
Not transferred.
Immovable.
So
not
so yeah, immovable properties are not transferred. Your basic property in a tea garden is the immovable property only. So
Yes.
now thing is that what is the need of bringing in these two parties?
Because it is a payment of the pension.
Mention.
So as per this agreement,
Hmm.
why we have brought this company has the warranty has been applied for, brought this company.
So
into
by this
picture
agreement, you have
because
agreed,
as-
you have agreed that after a sale is completed,
Eh.
then all
No.
this gratuity and all these things will be taken
No.
care of by them.
After no.
Then what?
After this gratuity, let's say come 31,
31.
page 31.
Yes.
It is hereby clarified that the vendor is solely responsible, that is
Hmm.
warranty will be responsible
Hmm.
and shall under obligation to pay the gratuity dues of all employees, permanent, daily related workers, staff, artisans, staff who are retired, design and died of the said estate, whether claim, unclaimed, accrued, may be accrued, including death cases for the period up to 31st December 2022.
Correct.
So after that,
Hmm.
this consignee will pay.
Hmm.
So therefore, they are necessary parties to the proceeding. Because it is an arrangement. Ultimately, if the tribunal found that the decision to withdraw the pension is bad, then they are liable. Why the impugn order is bad, Lordship? First thing, Lordship, section 10 of the Industrial Dispute Act,
Yes.
section 10(4).
Reference.
Reference. 10(4), Lordship, married, small. 10.
Yes, read.
Where in an order referring an industrial dispute
Hmm.
to a labor court tribunal or national tribunal
Hmm.
under this section
Hmm.
or in a subsequent order, the appropriate government has specified the point of dispute for adjudication.
Hmm.
The labor court or the tribunal or the national tribunal,
Hmm.
as the case may be, shall confine its adjudication to those points and matter incidental there.
So it is incidental there.
Not incidental. What is the reference?
It is incidental because this agreement has not been completed as yet.
No. There is no reference who will pay. Kindly come to the reference notification
Hmm.
at page 24. If that question has been formulated, then thing has been defined. Government, what reference has been sought? Lordship got it, page 24. whether the management one-sided to discontinue the pension benefit or retired staff is valid or not. So for deciding this issue, why this agreement for sale and other has to be discussed, whether decision is valid or not. If valid, employee will get the benefit. Benefit from whom get? It's from warranty. Till the sale is executed in between them. Second thing, the tribunal has directed the STIF to investigate criminal investigation of the matter. Where from he get this power? He's not the company law tribunal. He's not the civil court. He's an industrial dispute. He has to decide the only reference part only. Reference is very simple. Whether decision is valid or not. If valid, employee will get the benefit.
But he could not keep his eyes closed
No,
after seeing all these things.
no, all these things, nothing has been lost because this is the agreement for sale. Thereafter, it will take 1 to 2 years for completing the process of sale because government has analyzed everything. Thereafter, the stamp duty was fixed, then communicated to deputy commissioner, then deputy commissioner asked for registration of the sale deed. So there is a procedure. It is no property dispute. Here dispute is the decision is good or bad. So he has to confine to the question raised by the government only. So beyond that, he cannot go. Third, he imposed was 5 lakhs to per petitioners.
Okay. Anything more? Anything more? He says, Mr. Datta, anything more you want to submit? Mr. Datta, you want to add on something?
Yes. The tribunal has no jurisdiction beyond the reference, my lord. The settled position of law was 1963 by the Supreme Court in Delhi Cloth Mills Limited case, my lord, that the tribunal should confine itself.
In those cases, the learned tribunal could not find anything wrong in the process, but here they have found something
Even
wrong.
if wrong, even if wrong, my lord, the
Then
tribunal
what is
cannot
the
go.
recourse?
It is not
Then
a
what is
court.
what is the recourse for the? Then what is the recourse for the court to correct it then?
Not corrected. Court, the tribunal is to see that whether the withdrawal of the pensionary benefit is valid or not, my lord. That's only the cannot go beyond that. Tribunal has all those aspects, my lord. Put the tribunal is valid or not.
When is the next date fixed?
Already we have heard the management.
Tomorrow for final hearing and deposit and cost, and yesterday we have received a notice. He Sumutu registered a money execution case for recovery of the 15 lakhs, and according
Which 15 lakh?
5 lakhs each of the petitioner he has imposed. So for Sumutu,
Tribunal has no civil power, my lord.
he has no civil power to register a
How is Sumutu registered a execution case?
He has acted beyond his scope. Reference is very simple. Whether the decision is valid or not. If valid, employee will get the benefit. Warranty has to be paid because the sale has not been effected as yet. It is their internal management.
Dorsey, take an account. Please take, my lord, that in January 2003, Maduting has paid employees or we are not in the management.
Or one thing, the same tribunal, after hearing all
And in fact, by an impugn order, my lord, by an impugn order, he has answered the reference by saying that it is a legitimate pensionary benefit. He has answered the reference, my lord, by this impugn order. He said it is a legitimate pensionary benefit. He is using that word, my lord, the learned presiding officer.
Okay, we'll
before
do
adjudication, how
Mr. Datta will do one thing. We will take it up. I mean, I'll pass the order while taking up the matter, but we'll take up this matter after the bails are over.
Yes.
After the bail is on.
There are some bail matters, so we'll finish the bail matters at 2 o'clock.
Yes.
Then after finishing the bail orders, we'll take it up and we'll pass the
But
order.
we highlighted this case law.
My lord, my lord.
Then you can place those case laws and other things also. But we'll take it up after the bails are.
Right.
Time being here.
This allegation are, to some extent, they has to react some lordship, the violent behavior of the lordship patient.
Viral, nahi, violent.
It should not happen.
Viral is happening with everybody these days. Viral fever. Not viral, violent. Violent behavior.
Has been in custody lordship for
Hmm?
28 days. Petitioner is in custody lordship, 28 days lordship. This is 7 years, the offense is punishment up to 7 years.
The only difficult part is Lordship will find at page 24 in item number 14. Similar incident had already happened sometimes back. At page 24, Lordship will find. Lordship, point number 7, Lordship will kindly see. During investigation, it comes to light that the accused Manas Jyoti Soikia had earlier committed murder in his rehab, and in this case, the case has been registered, height so and so, and charge sheet was submitted also. So already a person has died.
Murdered.
So,
I may be permitted, my lord, in item number 14. In item number 14, I am appearing, my lord.
So there is an allegation of murdering also against you.
My lord, that is a
Charge sheet
case,
has been submitted.
my lord, that is a case of suicide, my lord, and I have approached this honorable court. Lordship, may kindly file this order.
You know what is there?
But nothing is against this petitioner, my lord. The person died by suicide, my lord. He has jumped from the building.
So that much of care you should take, na?
Hello?
That nobody can jump out, because those people who are addicted, they are in a different mental position.
All the precautions are taken, but somehow, my lord, he has jumped, my lord. This anticipatory bail was allowed, my lord, on the ground that nothing is against this petition. And I have made the statement in my petition. And my lord, in the forwarding report, my lord, if lordship may,
So you have spent how many days? 33 days,
28 days.
28 days. Mr. Sharma, let them go now. Let them
Lordship,
cooperate.
Lordship, one is AB, item 13.
13 I'll see. Now first, item number 12. Heard Mr. B. Haldar, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 483 of BNSS 2023 for paying for granting bail to the accused applicant in connection with Bishwanath Chariali PS case number 1122/2026 under sections 117 bracket 2 stroke 127 bracket 4 stroke 351 bracket 2 stroke 3 bracket 5 of BNS. An FIR was lodged on 3/6/2026 along with a complaint dated 3/6/2026 submitted by one organization, namely Anti-Drug Association. No, this is by one organization, namely Anti-Drug and Rehabilitation Center Association, in bracket ADRCA, before the District Social Welfare Department, Bishwanath, Assam, alleging inter alia that their association received video footage and information allegedly showing inmates stroke patients of Live Well Rehabilitation Center operating in Bishwanath district being subjected to severe physical assault, including beating with pipes and other forms of brutal treatment. Semicolon, that Such acts of violence and torture have been occurring since the establishment of the organization. Semicolon, that the videos and complaints indicate that patients are being physically attacked and subjected to inhuman treatment instead of providing proper care and rehabilitation. Next, in view of the aforesaid FIR and complaint. Now, in view of the aforesaid FIR, on the bed and in view of the aforesaid complaint dated 362026, comma, an FIR was lodged before the senior superintendent of police, Vishwanath, on 362026, enclosing the complaint dated 362026. And the same was subsequently forwarded to officer in charge, Vishwanath Chari Police Station. On receipt of the FIR, Vishwanath Chariali PS case number 112/2026 was registered under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicant is you are who?
He is one of the president of that society.
Submits that the aforesaid Live Well
Wellness center is a registered.
Live Well Wellness Center is a registered society under the Societies Registration Act.
Yes, sir.
Under the Societies
Page 17.
Huh?
Page 17, I have an example.
Under the Societies Registration Act and has been providing various facilities including the addiction facilities to the addicted persons, full stop. He submits that though one occasion has occurred some time back due to the situation demanded show, there was no intentional beating of the inmates. There is no inmates by the staff of the rehabilitation center. He submits that in fact the accused applicant is not involved in any such beating, and he is the president of the society, and president of the society not involved in any such activities. He submits that the accused applicant has been arrested by police and behind the bars for last 28 days. He submits that the accused applicant is a law-abiding citizen and shall not involve in any such activities and shall fully cooperate with the investigation in the event of his release on bail by this court. Full stop.
Rehab center already been.
Huh?
Rehab center already been sealed by the investigation. Rehab center already been sealed by the.
That is a different thing. Okay, last line, but what is it? He submits that his rehabilitation center, he submits that the concerned rehabilitation center has already been seized by the administration, and therefore there will be no occasion of involving himself in any of the activities that have been alleged in the FIR. Full stop. He further submits that he shall fully cooperate with the investigation in the event of his release on bail. Full stop. Mr. B. Sharma, the learned EPP, on the other hand, opposes the bail of the accused applicant by submitting that there are visual evidence available 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 about the alleged activities as narrated in the FIR. Therefore, he opposes the bail application. No, don't write this. ऐसे लिखो बट just come to stop there. Then you write. For hearing, the CD in the instant case has been produced and the same is produced by this court. Taking into account the entire facts of the case as well as the materials available in the CD and the fact that the accused applicant has already spent 28 days behind the bars, this court is of the considered opinion that further custodial detention of the accused applicant shall not be required in the instant case. Full stop. Therefore, it is directed that the accused applicant shall be released on bail on furnishing of bail bond of rupees 50,000 with a security of like nature to the satisfaction of whom?
Chief Judicial Magistrate Vishwanath.
Hmm?
Chief Judicial Magistrate
To
Vishwanath.
the satisfaction of the Chief Judicial Magistrate Vishwanath,
Assam.
Assam, subject to the following conditions. Number one, that the accused applicant shall fully cooperate with the investigation and shall make himself available as and when called for by the investigating officer. The accused applicant shall not try to influence it. Shall not try to influence, dissuade it. So and so. Then you write. Then you write. In terms of the aforesaid directions, the instant bail application is disposed. CD to be sent back. 13.
In B number 1297.
Hmm?
B number 129. Is prepared by Lotchi, secretary of that society. Unna has been.
It's a different society.
Same society.
Same society.
He has also been implicated by the
That live well,
Yes.
that the same society.
same society.
Right, heard Mr. Porokni लिख लो B Haldar Sada. Also लिखा, this is an application under section 482 of BNSS 2023, praying for granting pre-arrest bail to the accused applicant in connection with Visana Charili PS case number 112/2026 under section 117 bracket 2 stroke 127 bracket 4 stroke 351 bracket 2 stroke 3 bracket 5 of BNS. FIR to facts. Same facts, no? FIR?
Same
Yes.
Same facts. FIR to no? Here you go. B Haldar, Dalanet. Registration registered under Mr. B Haldar, Dalanet Council appearing for the accused applicant submits that the accused applicant is the president, is the secretary of the society which runs the aforesaid. Aforesaid, what was the name? Live Well.
Live Well Rehabilitation Center.
Live Well Rehabilitation Center. Rehabilitation Center. And he is not involved in any such beating of the inmates as that have been alleged in the FIR. He submits that since the FIR has been filed and one of the official of the society has already been arrested. He is also apprehending arrest in the instant case and therefore approach this court by filing the instant application application, he submits that he is a law-abiding citizen and shall cooperate with the investigation in the instant case. Full stop. Mr. B. Sharma, on the other hand, Mr. B. Sharma, the learned APP, has opposed the prayer for bail, prayer for anticipatory bail of the accused applicant, stating that there are sufficient materials of the allegations available in the CD. Full stop. Next one. Up to, CD in the instant case has been produced and the same is produced by this court. Full stop. Next one, after hearing the learned counsel appearing for the parties and on perusal of the case diary, this court is of the considered opinion that this is a case wherein the accused applicant should be given the privilege of pre-arrest bail. Full stop. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with Bishana Charlie PS case number 112/2026, he shall be released on bail on furnishing of bail bond of rupees 50,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, that the accused applicant shall appear before the investigating authority within 10 days of passing of this order. Number two, accused applicant shall fully cooperate with the investigation and make himself available as and when called for. Number three, that accused applicant shall not hate to provide. And right, next para, in terms of the aforesaid direction, the instant AV application is disposed of as allowed. This one?
He's the owner of Pratigya
Pratigya
Wellness
Wellness
Foundation.
Fund.
Same allegation.
Same allegation, same FIR, same forwarding.
Why do you beat up people, after taking their money? We take their money to de-addict them and then beat them up. And that to poor fellows like those are under the drugs. Heard Mr. A.K. Gupta, learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, the learned APP for the state. This is an application under section 483 of BNSS 2023, praying for granting of bail to the accused applicant in connection with Bishana Charlie PS case number 112/2026. In bracket corresponding to GR case number 273/2026 under section 117 bracket 2/127 bracket 4/351 bracket 2/3 bracket 5 of VNS 2023. Same type of complaint.
Same FIR.
Same FIR.
Same FIR. Everything is same. Only the foundation name is different.
And victim is
Same
different.
FIR. Facts to same thing.
Victim is different.
Kali naam to belek thaki. Foundation to naam to whole.
Pratigya Wellness Foundation.
Wellness Center. So and he's the
My lord, president of the society.
then you write Mr. A.K. Gupta, the learned counsel, appearing for the accused applicant, submits that he is the president of the society, namely Pratigya
Wellness Foundation.
So and so, and he is not involved in any such beating as alleged, any such beating of the inmates as alleged in the FIR. Full stop. He submits that the accused, how many days you were there?
28 days.
He submits that he is already behind the bars for last 28 days, and further, and his wellness center, his center has already been seized.
Sealed, my lord.
His center has already been seized. Therefore, he submits that his further custodial detention may not be required in the instant case. Mr. B. Sharma, the learned APP, on the other hand, submits that there are sufficient materials showing involvement of the accused applicant in the instant case, and therefore he opposes the bail of the accused applicant at this stage. Full stop. After taking into account, bail to into 11 to terms and conditions, same terms and conditions, same terms and conditions. Let them. What to bail us in na? Conditions can do. Which court? Same court, same court, same court.
We have not received a case diary.
Hmm?
Case diary not received.
Lordship, may peruse the forwarding at page
Case diary is still, you are Mr.
R4, Your Lordship.
Heard Mr. R. Kond, a learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, learned APP for the state. Case diary is still not received. Let the matter be listed
16/7.
on 16/7.
16 also same prayer, Lordship. We have not received the case diary.
Heard Mr. J.
Following the inspection, I may allow to do this.
Drawing.
Yes, Lordship.
Heard Mr. J. Islam, no?
Yes.
J. Islam, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, the learned APP for the state. Mr. J. Islam submits that he has instructions to withdraw the instant bail application, full stop. Accordingly, the instant bail application is dismissed as withdrawn.
17 also charge sheet submitted.
Charge sheet submitted, you go there.
49 days, Lordship. 49 days.
Yes, charge sheet has submitted. Your name?
A Gogoi, Lordship.
Huh?
A Gogoi.
Heard MS.A. Gogoi, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, the learned APP for the state. This is an application under section 483 of BNSS, 2023, praying for granting bail to the accused applicant in connection with the Dhammaji PS case number 82/2026 under section 61(2)/316(2)/318(4) of BNS. Full stop. The learned Mr. D.P. Goswami, the learned APP, appearing for the state, submits that charge sheet in the instant case has already been filed by charge sheet number
82/26 dated 29/6/26.
26. Full stop. In view of the aforesaid, the learned counsel appearing for the accused applicant submits that the accused applicant should be allowed to approach the appropriate forum for any relief if so advised. Also, accordingly, the instant bail application is disposed of with the liberty to the accused applicant to approach the appropriate forum or approach the jurisdictional trial court for appropriate relief if so advised. Kanlora Das.
Item 1, Mehboob Ali, na?
Yes.
Yeah, where is the affair, Mr.
Yes, Lord, the affair is in the page number.
Your bail application was earlier rejected.
No reason.
Okay, some other bail application you have given, order. What is that order? Same this thing,
Same district.
same FIR or no?
Yes.
Huh?
Yes, same affair, Your Lordship.
Same co-accused.
Yes,
Then you should go to that particular bench.
Disposed of by another court.
This is from Mr. Goswami. This is from the same FIR.
Yes.
So ideally it should go to that,
That-
to the particular bench,
Because
but the bench is not available. So in that case, Mr. Das.
dispose of by another court. Dispose of কৰি মিতালী বাইদেউ কোৰ্টে dispose of.
এখন বেলেগ হেৰি এখন আছে, বেইল অৰ্ডাৰ এটা আছে, কিন্তু নটিফিকেশন মতে নাথাকিলে, এভেইলেবল নাথাকিলে পাৰে নে কিবা এটা আছে নেকি? এইটো অলপ কনফাৰ্ম কৰি লওকচোন. Let it be confirmed, na, whether we can hear it or not. Because this, yeah, I mean, same FIR, other accused bail has been granted, na?
Exactly.
So, please confirm কৰি লওকচোন. It's from মিতালী বাইদেউৰ order এটা আছে. কালি কৈছিলে কিবা এটা. নোটিছখন চাই লওকচোন. এইটো order আছে. Same here, case number. সেই নোটিছৰ কপিটো পঠাই দিব মোক, নোটিছখনত অলপ চাই লওঁ, নহ'লে আকৌ মিছা কেছ নাম্বাৰ 225/2026 এইটো একেই. 25/2026 সোনাপুৰ কেছ একেই হয়. এবাৰ কনফাৰ্ম কৰি লওকচোন. Was allowed or rejected?
Oh, your lordship, the third number of.
No, it was allowed or rejected, the earlier one. Allowed, no?
Yes.
Allowed. Confirm কৰি. You wait for some time, let it be confirmed whether this bench can take it or not.
Yes.
Because earlier same FIR co-accused have been allowed by a different bench.
Take the cases, your lordship. First case, your
Have you
lordship.
filed any wakalatnama in this case? Have you filed any wakalatnama in this case?
Yes, your lordship.
Your name is not there in the cause list. Where is your wakalatnama?
Priyanki Das.
Yes. Yes, you have
Lordship,
filed.
it is a shown arrest case, your lordship.
Hmm.
In the main cases, he already got bail, your lordship. And your lordship, I would like to take you to the previous cases, your lordship, where bail has already been granted, your lordship. That is Annexure 2, which starts from page 17 to 20. For the background of the cases, your lordship, this anticipatory bail, your lordship, was
second.
filed. And that your lordship was granted.
1 second, MS Das.
Yes, your lordship. Page 17, Annexure 2. AB 1169/2026. Mehboob Ali and another. Bail was granted on dated 12/6/2026. Third paragraph onwards, your lordship, the FIR in connection. May I read, your lordship?
Wait for a minute. So you were given, you were given anticipatory bail.
Yes, your lordship.
Then what happened, on
lordship.
12/6/2026, you have been given anticipatory bail.
Yes, your lordship.
Then
And that was leaving-
26/6, what happened?
Then your lordship, thereafter your lordship, PS case number, yet another case was registered. Same PS, that is Jalukbari.
Jalukbari, PS case number 213 was.
213, 2026.
correct.
There also, your lordship, I was granted, your lordship, bail,
Hmm.
regular bail, that was annexed as annexure 3, page
Correct, yeah.
21.
Now,
Thereafter, your lordship, when it was, your lordship, it was clearly given, your lordship, paragraph 5, that is page 22. I would like to read it, your lordship. The Learned Senior Counsel has drawn attention to previous order dated 12/6/2026, which was passed by this court with regard to the petitioner in AB 1169 of 2026, in which the court was placed to grant pre-arrest bail.
no,
to
correct,
the
that has been given,
petitioner.
yes, yes. I
Yes,
mean,
your lordship.
and that was.
Thereafter, your lordship.
Wait, listen, that part was considered,
Yes,
and
your
after
lordship.
consideration, bail was granted to you.
Yes, your
Huh?
lordship.
Yeah, that AB was granted to you in 213. Now, that was a bail application.
Bail application.
You have been
regular bail
arrested.
Application. Regular bail application.
So when you were arrested?
Then again, your lordship, after getting all these cases, all 2 cases, your lordship,
Hmm.
I got bail, your lordship.
So you
on-
get bail, yes,
Yes,
then?
your lordship.
Hmm.
Thereafter, your lordship, 1 cases has been, I would like to take you to the forwarding report, your lordship, annexure 4, page 26.
Hmm.
Prayer for shown arrest, 5 days police custody of accused person in connection with Gorsu. Here now, Jalukbari, other 2 cases were in PS Jalukbari. And now this was fabricated case, your lordship, similar, your lordship. And it was alleged that Gorsuk PS case 129/2026 under section 13 and 14. I will definitely take you for these sections, your lordship, elaborately. But PS case number 129/2026, that is under section 13 and 14 of the Assam Cattle Preservation Act 2021,
Hmm.
read with section 11.
Hmm.
Now, Prevention of Cruelty to Animal Act.
Hmm.
How can I, your lordship, to offend this cruel, your lordship? I cannot make a cruel, your lordship, regarding, because my physical presence will be needed to do this offense, your lordship. How can this section be attracted towards me? Alleged, your lordship. Alleged sections were 13 and 14. To do cruel, your lordship, my physical appearance is needed, your lordship, to make them, your lordship, to offense this offense as your lordship, Cattle Preservation Act. So, your lordship, I cannot be present physically to cruel those animals, your lordship. And moreover, your lordship, this shown arrest was made, your lordship, intentionally, your
We'll call
lordship,
for the,
by-
we'll call for the city.
Lordship.
your lordship, already, your lordship, co-arrested statement has no evidence. And moreover, your lordship, notice has not served, your lordship. And I would like to take you
No, we'll
to,
call for the CD and we'll consider on the next date.
your
Heard
lordship,
Mr.
on
P, the
to
please,
your
MSP
lordship,
does.
on to your lordship,
On to?
Gorsuk itself. And moreover, your
on
lordship,
on
forward
MSP.
notice has not been produced.
Then you can bring in all these things on the next date.
Already, your lordship,
All the
here-
next date, you can bring in all these
Then
things.
your lordship,
Okay.
any date.
Let
you-
us see why this case was filed and what was the reason of filing this. Why cruelty to animal has been brought, allegation of cruelty to animal has been brought in. So court, without looking into the materials, cannot take, whatever you have said to be granted, correct?
Your lordship, only request is that this is Gorsuk, your lordship, very nearby.
16/7.
On
16/7.
your
Earlier
lordship.
Before that, can you
Before
give it?
the-
Vacation code is there.
Yes, here, your lordship, Gorsuk itself too, or any vacation date, your lordship.
Okay. No. And then reopening date, immediately after reopening. Heard
Before
MSP,
that, your lordship.
heard MSP Das, the learned counsel appearing for the accused applicant. Also heard Mr. DP Goswami, the learned APP for the state.
lordship, here is a fit case, your lordship,
I
because
understand here is a fit case. All cases are fit case for the council, but all cases are not fit case for the judges.
because
That is the
notice
problem. That is the problem I'm saying, you know. This is an application under section 483 of BNSS 2023 for granting
Then I
bail
would
to the
like to
accused.
withdraw this petition, your lordship.
Heard MS P. Das, the learned APP for learned counsel appearing for the accused applicants. Accused applicant also heard Mr. D.P. Goswami, the learned APP for the state. Mr. MS P. Das submits that she has instructions to withdraw the instant case. Full stop. Accordingly, the instant bail application is dismissed as withdrawn.
The lordship will find the earlier order lordship is a field.
Hmm?
The lordship order is the phase 18 law.
Hmm.
At this state lordship, I am paying for a calling for a case diary.
You are still not arrested.
Because he is a
Hmm?
tender agent,
You are a very clever person.
20 years.
Hmm?
Years is a tender
Rejected.
agent for-
No bail. Heard
I have-
Mr.
I
B.
have
Halder.
stated the ground lordship kindly pay the
I heard Mr. B. Halder, the learned counsel appearing for the accused applicant.
case for-
Also heard Mr. B. Sharma. What?
I have stated the ground.
What ground?
With the IO at the time of incident, lordship,
Hmm.
seized the mobile phone of the victim, lordship.
Hmm.
There was a allegation that the
Hmm.
immediately before the committing suicide, the
Hmm.
accused called the victim, lordship.
Hmm.
If the accused, lordship, really had called, lordship, it will reveal in the call details of the victim, lordship. In that legal, lordship, there is a development, lordship. Kindly call for the case then, lordship. Because he is a very tender agent boy, lordship, 20 years. If he is arrested, lordship, with PDR.
After committing the crime, you left to Kerala. Correct. And like in Kerala, you were there for some time
After
and
reaching,
making all the fun there, and then you came back here. Then again you started disturbing the girl,
No, no,
and the
after-
girl committed suicide.
after coming back from the Kerala, lordship, he has not contacted the victim.
No,
lordship. It is
no.
the victim who contacted the accused, lordship.
No.
The accused has already informed their guardian, lordship. And on the day, lordship, the mother of the victim.
No.
lordship,
This court is not going to grant you bail.
Kindly,
Don't argue anything more.
Can you
Heard
call for
Mr.
the
B.
case
Halder.
diary, please?
No quick case that is required in this case.
Because-
Mr. Case was dismissed earlier, or the bail was rejected earlier on perusal of case diary. Detailed perusal was done. After that, your bail was rejected. You have come again. So I don't have any other option to reject it. Okay. There is no ground. Heard Mr. B. Halder, the learned counsel. Hmm?
There are lordship, those things were earlier not brought to the notice of this. court,
Those things were
lordship.
there in the CD, whatever was there. I mean,
Up-
your facts are not required. The facts in the case diary is most important.
Because after arriving
Hmm.
in Kerala, lordship.
Your
he-
facts are not required. The facts in the case diary are required. In the investigation, what has come up is required. Sufficient materials have been found about your involvement, and after due consideration, your bail was rejected. And you have come only after when it was rejected, 862026. And today is what? 362026, and after 22 days only you have come without any substantial ground.
Can you-
So you probably have your own reasons to file this bail application. I also have my own reasons to reject your bail application. So I'll have to reject it. Heard
I'm
Mr.
just
B.
go down to
Halder.
the magistrate.
Please don't insist.
Yeah,
Heard Mr.
okay.
B. Halder, the learned counsel appearing for the accused applicant. Also heard Mr. D.P. Goswami, the learned APP for the state. This is an application under section 482 of BNS 2023 praying for granting pre-arrest bail to the accused applicant in connection with London PS case number 25/2026 under section 108 of BNS 2023. An FIR was lodged on 24/2/2026 by the informant alleging that his daughter, aged about 16 years, was mentally tortured by the accused applicant for the last 2 years with proposals of love, semicolon, that due to such harassment, his daughter had to have had to remain absent from taking her examination for 1 year. Full stop. Semicolon. That thereafter the accused applicant went outside for some time, and thereafter again, then again came back and started harassing his daughter again. And started harassing her daughter. Semicolon. Due to such harassment, the minor daughter of the informant had committed suicide by hanging herself. Full stop. The learned counsel, then you write, uh, an anticipatory bail application, that is bail AV number 1071/2026 was filed earlier by the accused applicant, had been rejected by this court by its order dated 8/6/2026 after perusal of the case diary. Full stop. The learned counsel appearing for the accused applicant submits that the victim and the accused applicant were in fact involved in a love relationship, and there is no material to suggest that the accused applicant had harassed the victim and therefore the victim had committed suicide. Full stop. Therefore, he submits that the accused applicant should be granted the privilege of pre-arrest bail. Full stop. Mr. D.P. Goswami, the learned APP, on the other hand, opposes the prayer of anticipatory bail, submitting that that his earlier bail was rejected on perusal of the case diary, and there were sufficient materials available against the accused applicant in the case diary. Therefore, he opposes the prayer of bail. Therefore, he opposes the prayer of bail of the accused applicant. Full stop. Then we read next para. This court has heard the respective submissions of the counsel appearing for the parties and has also perused the materials that has been brought on record by way of the bail application. Full stop. After considering the submissions and on perusal of the materials before this court is not inclined to grant any relief to the accused applicant at this stage. Accordingly, the instant AB application is rejected and disposed of. Some other time. Not a good case.
Also here.
Lordship is a gynecologist, madam. He was one.
How come the gynecologist in the court?
What has happened, my lord, regarding the part of a baby, my lord?
Hmm?
There was deficiency in the baby, my lord, physical disability.
Where is the FIR?
FIR, your lordship will find that page
18 on it.
18, my lord.
Page 18.
Yes.
It was lost by one Mithunjay Bora. He said your wife was regularly treatment of medical since last 9 months.
Yes. What is the contents of the FIR?
That on 25/6, I along with my wife visited Dr. Amol Soika for checkup. The requestment told us that is okay. Weight of the child is around 3 kilo 20 grams. At the same time, he suggests to admit my wife whenever she feels inconvenient. According this morning 3:30, I brought my wife to KP and Memorial Hospital. As per hospital authority, my wife was admitted and the accused person was taking care of my wife. It was around 7 a.m. Along my relative associates heard some cry and some newborn baby, which we were asked the nurse and the hospital authority about the was going inside. Thereafter, accused person went out from the operation with a newborn baby on his lap and told us that female baby has been born with some physical disability, which actually shocked and surprised all of us during the whole period of treatment. Accused person never told us about deficiency towards the baby and who was in the womb, but suddenly this morning doctor handed over newly born baby with physical disability. Then next page first. So far my knowledge was that then she wants to tell that there was willful negligence on the part of the accused person because when we have seen the physically disabled baby, ask the accused person about the reason why.
So baby is alive.
Alive, everything is alive. Disability is something to do with deficiency in the mother matter. Alias, you also one. There was a
Now deficiency means, I mean, what kind of deficiency now?
deficiency because he was foetal anomaly was there.
Huh?
Foetal anomaly.
And now the boy is not normal or what?
Normal, but the only these fingers were not
Properly developed.
developed. As because when then
And allegation is that like he has been examining this lady for a long time.
yeah, and he says that we in the prescription
Hmm.
that foetal anomaly we have written it. He says later on we have written, not early, because we have advised him to go for foetal anomaly scan. That's that is important scan is and he hasn't done it, is costly affair, but he has not done. So if the scan is that there even if deformity is there, that can make out in the scan. He says that fortunately by way of temper, accused person had written the foetal anomaly scan in one of the prescription. Thereafter, he tried to destroy. It was already there in the prescription.
What is the prescription?
It was there in his custody, in their custody.
Prescription is not there.
No, it's not
there. It's not annexed here.
Not the next we have in the prescription, we don't keep prescription. It was given there in the advice was given there for foetal anomaly scan.
Okay.
But he did not do it, man. Then he says that.
So that is the problem because the doctors do not keep the records.
The outgoing version, in the medical record may be there because I was a visiting doctor there, man.
You'll be also knowing, like other states. I mean, I have a friend, some friends that were working outside. I mean, if they do this kind of clinical duty for 8 hours or 10 hours, 3 hours, more than 3-4 hours they spend. I mean, writing those things. I mean, digitally inputting all those records in the thing, computer.
The prescription we have advised from foetal anomaly scan, but that was not done. And anyway, but all the offenses are available. Now they have LS 406, man. 406 cannot be.
406 is what?
Breach of trust.
Criminal breach of trust, man. They have not had any medical negligence case also, man. Nothing like that. And there's no case of medical negligence also. When the baby was born, alien, only the deformity was there because of the problem with the mother, man.
Okay, this is in Biswanath Chareli.
Yes, Lordship.
Everything, madam, 406 is not made out, man.
Yes, Bora.
Lordship, otherwise there is a reflection of that they have done a serious offense of negligence as well as perjury by inserting some new facts. in the old
Okay, I mean, there may be some part of this, but at
Not
this
sure.
stage, I mean, let him cooperate with the
That
investigation.
Otherwise also section 35(3) notice has been already issued to the petitioner lordship. That
Let him
will-
appear, go and appear. Heard Mr. P. Kotoki, the learned senior counsel, assisted by I. Hazarika, the learned counsel for the accused applicant. Also heard MS SH Bora, the learned APP for the state. This is an application under section 482 of BNSS, 2023 for granting pre-arrest bail to the accused applicant in connection with Vishwanath Chariali PS Police Station case number 141/2026, registered under section 125/316(2)/336 of the BNS 2023 in bracket corresponding to GR case number 334-2026. An FIR was lodged on 28/6/2026 by one Mrityunjay Bora before the officer in charge of Biswanath Sariali Police Station, alleging inter alia of medical negligence, forgery by inserting some new facts in old prescription, breach of trust against the accused applicant as the wife of the informant gave birth to a female child with some physical disabilities under the supervision of the present accused applicant, who is a doctor, who is a medical doctor by profession. Full stop. Next, on receipt of the FIR, the police registered the Biswanath Sariali Police Station case number 141/2026 under the aforementioned sections. Under the aforementioned sections. Full stop. Mr. P. Kotaki, the learned counsel appearing, my learned senior counsel appearing for the accused applicant, submits that there is no negligence on the part of the accused applicant in the instant case as far as the deficiency of the mother of the child had been already intimated to the informant along with his wife during the physical examination of the mother of the child. He submits that this aspect of the matter has already been recorded in the prescription that has been issued to the informant. He submits that the child was duly born, but certain
Deformity.
Hmm?
There was deformity. I had-
duly born with certain deformities. There are certain deformities. Full stop. He submits that certain examinations advised by the accused applicant had not been followed by the informant's wife, and that may be a cause for such deformities. He submits that for those aspects of the matter, the accused applicant cannot be held responsible under the sections that have been mentioned in the FIR. Full stop. He submits that the accused applicant is a pediatrician.
No, he's a
Oh, sorry, he is a gynecologist. Is a renowned gynecologist of Biswanath Sariali, and has been in medical practice for
last 40 years.
several
For 45 years.
for
Last 40.
45 years.
40 years.
Like last 40 years. Full stop. He submits that he is a responsible citizen and fully cooperate with the investigant in the instant case, and abide by whatever conditions that the court deems fit in the event of his prayer being allowed. Full stop. Bora, what do you want to say?
Lordship,
As usual, opposing.
yes, Lordship.
Uh,
Because already 3 notice has been issued to them. There is no apprehension on the top of that, Lordship. That's my point.
see certain things in the society you'll also have to look into, because
Yes,
he's a
so
doctor
otherwise-
there.
Yes,
He has served there for 40 years. Yeah, maybe
Yes.
some issues here and there
Lordship.
happens. But for that, I mean, like the person will be put behind a bars,
Lordship,
and that whole societal stigma,
Lordship.
everything goes. I mean, especially in some professions, that's very
Lordship.
that is why, I mean, Ms. S.H. Bora, the learned APP, on the other hand, opposes the bail application, prayer for anticipatory, prayer for interim, prayer for anticipatory, prayer for pre-arrest bail, and she has submitted that section 35(3)
Lordship.
notice has already been issued to him, and there is no apprehension as such. I'm recording whatever you're saying
Lordship.
as such, full stop. Next para you write. The this court has heard the submissions made by the counsel appearing for the respective parties, and having parties, and have also perused the documents and materials that have been enclosed in the instant bail application. After considering the entire facts of the case, this court is of the considered opinion that the accused applicant should be given the privilege of pre-arrest bail at this stage. Full stop. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with Biswanath Chareli Police Station case number 141/2026, he shall be released on bail on furnishing of bail bond of rupees. He should be released on pre-arrest bail on submission on furnishing of bail bond of rupees 50,000 with a surety of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, the accused applicant shall appear before the investigating authority within a period of 10 days of passing of this order. Then number two, the accused applicant shall cooperate with the investigation and shall appear before the investigating authority as and when called for. Number three, the accused applicant shall not, that you write, and that shall not dissuade and evidence and so on. Then next paragraph. In terms of the aforesaid directions, I'm disposing it of.
Yes.
In terms of the aforesaid direction, the instant AB application is disposed of as allowed.
Obliged, Lordship.
Yeah, পকা বলে দিন। ওটা শুনুন। কি ছিল? যেতে পারি না বাবা? In case of special accused in the same offense, bail application is preferred. Rejection of earlier bail application is only decided once. When earlier decided, this was embarrassed even the registration in state. And there was registration about video conferencing. কোথায় কোটিখানে নেই
তেওঁ মানে ঠিক কালি প্রস্তুতি তেওঁ ফিজিক্যালি প্রেজেন্ট এই সেম একুশ নিজে এখানে তুমি ইন্টারপ্রিটেশন তো চেঞ্জ করে
কিন্তু সেম একিউজ বুলি কৈছে ন সেম একিউজ ইন দ্য সেম এফআইআর বুলি কৈছে সাবসিকুয়েন্ট বেল হলে কিন্তু এইটোতো কেছটো বেলেগ এইটো বেলেগ এইটোত পাৰিব চাগে। এইটো বস্তু এইটো লিখছে মানে is not holding the criminal roster নাই যদি station difference and the jurisdiction of the high court direction would not be applicable. Mr. Goswami, we can take it. I think this bench can take it because that sister is not there,
Yes.
and this is different. This is not of the same accused. It is different accused.
Lordship. FIR is same, Lordship. Only
FIR is same, but the different accused. If it would have been same accused, there is no other way.
no other way.
It had to be it had to go to the same
Maintenance.
judge. But if it is a different accused,
Lordship
I
can-
think it can be taken. Yes,
87 days India,
he's already 87 days.
87 days.
So only thing is that Lordship, we have to, any charge sheet was filed or not, that's we have to take instruction regarding that.
And other accused have already been
Granted
rejected,
bail, yes.
already been granted.
Only that part, but Lordship can,
Any information, charge sheet? What?
Actually, your lordship, as per the information, no charge sheet has been
Filed till date.
admitted.
Okay, we'll 87 days, we will allow him.
Lordship.
Heard Mr. J. Rahman. J. Rahman, the learned counsel appearing for the accused applicant, also heard Mr. D.P. Goswami, the learned APP for the state. This is an application under section 483 of BNSS, praying for granting bail to the accused applicant in connection with Sonapur Police Station case number 25/2026 under sections 103 in bracket 1, stroke 126 bracket 2, stroke 189 bracket 1, stroke 191 bracket 2, stroke 191 bracket 3, stroke 238 of BNS. You were named in the FIR, not named?
No,
Not
my name
named.
has not been mentioned in the affair.
You're right. On 2/4/2026, an FIR was lodged before the officer in charge of Sunapur Police Station by one Julie Chauhan, alleging, inter alia, that on 1/4/2026 at about 5 p.m. her son went to his elder sister's house at Kendubosti by bicycle. Bicycle to stay for the night as her son was in love relationship with one ex. And they had been in contact for a long time. That the aforesaid ex threatened that if she does not bring her son, that she would commit suicide. Semicolon. That accordingly on 11/4/2026 at about 11 p.m. her son went to the house of the aforesaid ex at Jarikusi without informing his sister. Semicolon. That on which that it was that the accused persons allegedly physically assaulted the informant's son with sharp weapon and bamboo sticks. And thereafter, he was thrown near railway line at Jarikusi. That later on, with the help of the police, her son was recovered and admitted to Sonapur District Hospital and later on to GMCH. That, however, on 2/4/2026, her son succumbed to his injuries at GMCH. On receipt of the aforesaid FIR, the police registered Sonapur Police Station case number 25/2026 under the aforementioned sections. Where is the FIR? Page?
Page number 9, Your Lordship.
And what is your name?
My name is, Your Lordship.
Conlora Das.
Yes.
He's not there in the FIR, no?
No.
The unknown, about 15% already. That unknown person maybe.
Okay. Then you write Mr. J. Rahman, the learned counsel appearing for the accused applicant, submits that the accused applicant is nowhere involved in the incident case and he was not at the place of occurrence at the time when the alleged incident happened. First of, he submits that though several persons have been named in the FIR, his name has not been mentioned in the FIR, and there was no specific allegation against the accused applicant. He further submits that the accused applicant has already spent 87 days behind the bars. Therefore, at this stage, he should be allowed to go on bail. How old are you?
As per petition, 35 years.
Okay. Allowed to go on bail, full stop. Mr. D.P. Goswami, the learned, then you write, he further submits that that similarly placed persons, and these people are named or not named? Sarat Chandra, Sarat Hira and 4 others?
Not named.
They are also not named. He submits that some similarly situated persons were also not named in the FIR. FIR had approached this court by filing a bail application, that is bail application number 1460/2026, and this this honorable court had granted them bail after perusal of the case diary. Full stop. In view of the aforesaid, he submits that the accused applicant should be also granted bail. Mr. D.P. Goswami, the learned APP, on the other hand, submits that without perusing the perusal of the case diary, the accused applicant should not be granted bail at this stage. Full stop. Next para. After hearing the parties, after hearing the submissions made by the respective counsel, this court, and also on perusal of the materials brought on record, this court is of the considered opinion that the accused applicant should be granted bail at this, and also taking into account of the fact that he is already behind the bars for last 87 days. This court is of the considered opinion that the accused applicant should be granted bail at this stage. Accordingly, it is directed that the accused applicant shall be released forthwith from jail on furnishing of bail bond of rupees 30,000 with a security of like nature to the satisfaction of whom?
CGM Kamrup.
CJM?
CGM Kamrup Metro.
CJM Kamrup Metro, Metro, subject to the following conditions. Then you write number one, that the accused applicant shall cooperate with the investigation. Accused applicant shall cooperate, okay, accused applicant shall not try to, that clause you put out, shall not try to dissuade it, this thing. Then you write 1, 2. Okay. Then you write in terms of the aforesaid direction, the instant bail application is disposed.
Highly.
Timing item 10:11.
A humble prayer before Lordship.
Hmm.
I was to leave the court because our list is already over.
Yes, please, please.
My lord, perhaps I am audible now. May it be please, my lord. I'm sorry, my lord.
No, why don't you like to come to Gauhati?
I have always liked to, I am happy to, my pleasure, my lord, to appear before this court. But the only problem is, my lord, that we will not dispose the entire matter today itself. So only we require a stay, and for satisfaction of this honorable court, laid some points, my lord. I am very sorry that at this odd time, and that to any vacation court, we have to.
No, see, like I think see, this is you have come against an interim. I mean, kind of an this order. No, this is not a final order.
Absolutely final order. No, I'm just for satisfaction of this honorable court, my lord. My lord is aware that in the tea state there cannot be an absolute sale. This is number one, because all this in tea state there cannot be an absolute sale, because it's all grant land, my lord. So this leasehold right can be only assigned. Now this agreement in question, which is questioned by the industrial tribunal, that is absolutely out of the jurisdiction of the court. Why, my lord? Because the labor court or industrial tribunal is not a court. It is a certain law that all tribunals are not court, but all courts are tribunal. Lordship is aware. And the lordship there is no power of the labor court or industrial tribunal to impose cost, to invoke the power under section 35 and 35A of the CPC. The labor court having an only jurisdiction to confine itself within the periphery of the points for reference. And here the reference is that whether the discontinuation of the pensionary benefit is valid or not. Now, labor court only answered this, that it is whether it is valid or not. The labor court has no jurisdiction to travel beyond it. This is number one. Number two, my lord, that the labor court also referred entire matter to the Serious Fraud Investigation Office of the Companies Act, saying that all these transactions are same transaction, all invalid, all are they committed fraud. And also saying that we have committed to be robbed us under section 120B, my lord. We are transfer the management, employees, everything to a new incumbent. The manner of transfer says in the agreement that all the employees are now transferred to the new incumbent. And we say in the agreement that this leasehold right on a future date will be assigned by a appropriate deed of convenience. So therefore, we are not saying that it is a sale, because we cannot sell it also. It is a leasehold right. It's granted by the government to have a tea garden, tea plantation manual since long, 100 years ago. So since there is some financial difficulties, the company decided to hand over the management and all the assets.
Why do you use this word sale, agreement to sell?
Agreement to sell, there may be.
It is only leasehold.
What I understood, my lord, is there may be some using the words.
It is immovable property as well as movable property, right?
Correct. What I can sell, my lord, I can sell the bushes, which my property. I can sell the movable of the machineries, etc. I cannot sell the land. The land belongs to the government. So, and we are going to, your lordship is, since I am doing I'm living in the plantation area, I know that there are many gardens by this way transferred to new incumbents. And the process of this permission, because the permission cannot granted by the deputy commissioner, permission has to be accorded by the state. Now, my lord, what bothered us actually, what was the illegality committed by the labor code is that if lordship is already read over the order. Now, lordship, there is a page 231. The learned tribunal says that we are deprived the legitimate claim of the workman.
Those
By
things are
saying,
fine. See, I'm Mr. Datto.
and another, just a minute, my lord. Just a minute. Just a minute. Another thing, my lord, the section 10, section 11.9, saying that the labor court and tribunal having a civil power. Civil power. But the labor code has no power to execute its own order. Section 11.10 says that the order be sent to the civil court, and civil court will execute it as if the civil court passes the decree or order. But yesterday, my lord, we have received a notice wherein the labor court itself, suo motu, registered a money execution case. It is absolutely unfortunate. If it is going on, it is also affect the employee's right, because he's travel far behind. So whatever the labor court is to decide,
Yes,
he
Mr.
is
Datto.
travel.
So basically, to summarize, your contentions are that the matter was going on, and warranty had an agreement with these two other
Entities, other two entities.
other entities, and there was a agreement for sale. And
Correct.
accordingly, the agreement to sale was going on. I mean, in terms of
Execution of the
sale,
final deed, my lord. Final
in
deed.
terms of the agreement to sell, but the final sale deed has not happened as yet. And
Correct.
and as far as the reference is concerned, reference was done prior to your prior to warranties entering into the sale agreement. So the
Correct, my lord.
reference was sent there, and reference was sent for particular two purposes. One purpose is whether that your policy of stopping the pensionary benefits to retired officials were correct or not. That is the main contention. So that was the reference sent to the industrial tribunal. And while the matter was taken up, you pointed out that since we have already transferred, there was an sale agreement, and we have already transferred certain parts of in terms of the sale agreement.
Absolutely, everything, my lord,
We have
including the
transferred-
employees.
we have transported, but though the sale agreement hasn't happened, but so therefore these two parties are necessary parties, and they should be included in the instant case. Accordingly, the presiding officer included those parties, but later on the presiding officer got changed, and another presiding officer came, and like he found that he went beyond his reference. He found out that he came to a conclusion that these agreements are not correct, this and that.
Yes, correct, my lord.
And accordingly, he passed the instant order. I'm saying that that intentional delay has been done by these parties, and therefore these two parties have been already.
They struck up.
They struck off their names. And directed that the cost of this much on these three parties.
Correct, my lord. Absolutely correct.
So you have come against
this order.
The order, and now you have stated that you have received one notice saying that a suo motu case has been registered against recovery of this 15 lakhs cost that has been put on you. Correct?
Correct, my lord. And I'm just only add one thing, my lord. I want to add the impediment order. That was a consenting order by the management, and Consenting order, my lord, because the union also appreciated that new incumbent come. Now they are the employer, my lord.
Correct,
They
correct.
are the employer as
So,
per the as per the industrial dispute.
that is your
Main contention.
submission as far as facts are concerned. As far as legal things are concerned, you are saying that like under section 10.
Yeah.
Uh,
10-4.
huh?
10-4, my lord.
Under section 10-4 of Industrial Tribunal Act, a reference has to be decided as per
Confined.
as the reference has been sent, it cannot go beyond, it cannot
Beyond the same.
travel beyond the reference.
Supported by
Yes, formulated by the
Court,
concerned government authority. Now, your submission is that since it has gone beyond this thing, they have ventured into looking into the legality of the agreement, this and that. This is not correct. And secondly, the putting cost on you is not correct because this industrial tribunal doesn't have the power to put cost because it's not a civil court. Are you saying so?
Yes, my lord. Yes, my lord. Yes, my lord.
You're
And
saying
my
so?
submission, my submission is supported by the Supreme Court judgment and also, my lord, the dishonorable court in two judgment by Justice B.K. Sharma and another judgment, my lord. It supported that the tribunal cannot enlarge this scope. Here, enlarge this
So
scope.
that is
That's
that
my
is
submission.
that
Yes,
is
my
your
sir.
also, Mr. So that's why your prayer is that this order should be
Stayed, my lord.
order
The proceeding may be continued, my lord. Proceeding may be continued. Proceeding may be continued, but only difficulty is that already the tribunal has struck off. Yes, that's the problem.
Two persons have been struck off. Then
Yes,
what is
that's
to
the
be done on
problem.
that?
Yes, that's the problem. Otherwise, the proceeding can be continued, my lord. It can be continued.
But like the
But we will put in order. We will serve the notice, my lord, and all expeditious effort to be done by us, my lord, to early disposal of this case. Because of the stay, it cannot be the
stay will
original
affect-
proceeding.
Stay
Yes,
will
ma'am.
affect those
Yes,
retired persons.
adjudication.
Retired persons.
That we have to take care of. That I am exceeded. That's my submission. But without the presence of this, my lord, the Mr. Decker's client, how could this?
And is there any different prayer in these two? These two?
No, same.
No, same prayer, my lord.
Same prayer.
Same order, my lord. Same order. Same impugn order. Same prayer.
Okay, then I'll pass the order in the chamber only. I mean,
My-
rather than like keep you waiting on, or should I pass it
lord.
here only?
Is our pleasure, my lord.
As per your convenience.
If any missed out, we can just.
Yes, madam, you have anything to say?
I'm appealing for respondent number 1, Lordship, State of Assam, Lordship. In this case, Lordship, the main respondent is the respondent number 2. Again, that the Kormachari Sangha, Lordship. So they are
The retired
without-
employees.
yes, they are
Workers'
the
employees,
Kormachari
ma'am.
Sangha.
Indian.
Association.
Assam Karmachari Sangha.
But Lordship, in this case, Lordship, in the year 2022, Lordship, that the reference case is filed, Lordship. And subsequently, they have informed that in the year 2023, that only because of the sale agreement, Lordship. On that basis, they have discontinued the pensionary benefit prior to that, Lordship.
No, prior to that, and that is the reason that sort of reference was made.
Yes, Lordship.
Because they raised some serious dispute.
Yes, Lordship.
This.
Subsequently, inform the reference code that there is a
So,
sale
madam, we'll
agreement
do
that-
one thing. We'll stay this order and like we will post this case immediately after reopening.
15 and 16, I will be there. Up to 17, Lordship may fixed it. 17 July, man.
So 17 July we'll fix it.
Yes.
17 July we'll fix it. And this stay will be till 17th only. On
My lord.
17th, we'll see what is to be, what if, I mean, who is there, what is their contention?
Yes.
And accordingly, we'll do,
We take the
care.
step tomorrow.
You take the
Steps
steps,
under respondent
is
number
take the steps by
by
tomorrow.
the year.
And so in terms of this, I'll pass the order.
My lord. Grateful, my lord.
There is no other issues involved in the other case, no?
No, same.
Same, my lord. Same order. Same.
Only thing is that Warren has
Lordship.
transferred this to Dhansiri and
Dhunseri and.
Moduting,
Here
Moduting.
purchase are company.
Moduting.
Yes, Dhunseri
Moduting
purchase
Private Limited.
and Moduting purchase one girl.
Mm.
One order can also pass in the common order can pass because issue raised in the similar.
A link case, my lord, link case, link.
Both the cases
Both are
can-
common order.
Common
link
order.
case.
Okay, I'll pass the order.
Ma-
I'll sit in the chamber and pass it. No,
My,
pass the order.
my. Grateful, my.
Extra. বাইদেউতো rule নাই তথাপিও বাইদেউক দিব দিম।
দিব দিব পঠাই দিব লাগিব।
বাইদেউকতো আজিয়ে দি দিব দিয়ক পইচাটো গম পাইছ? পইচা আকৌ order sign নহলে নল'ব হেৰি নহয়। হ'ব তাকে ready কৰি xerox কৰি হেৰি কৰিব।